Um, there you go. Yes. This is Wednesday night. This is David versus Goliath, normal Wednesday night evening. Usually we call it Crybaby night, but we have a special guest, Lorin, to come in here, who is a real trooper, a real gladiator in this arena, who I've met and sat down and talked with. Very knowledgeable, has gained a lot of knowledge, and knows how to proceed in the courts in many different levels. Okay, and what I want you to tell, because he's done some things that caused him to be indicted on something, and I'd like him to talk from the beginning and how he got to from that point to where he's at today after going in court, because he was indicted on some issues, and I want him to go ahead and talk about that. Everybody just hold off your question and stuff like that until he's done. This is Lorin Buckner.
All right. Hi, Lorin.
All right. Hey guys, how are you?
Good.
Fine.
Well, let me start out at the beginning. I've been in foreclosure work for a long time. I've been doing that for a long time, and in the process of doing foreclosure work, I noticed a pattern of banks and how they were moving with these foreclosures, and I have about 8 or 10 people that live in their own personal homes that don't have mortgages because the banks didn't have the paperwork, go to court and ask for certain things, they couldn't produce it. So I had a process that worked really well. My mortgage was being held by Washington Mutual, and they were in bankruptcy, they were in trouble, and they came at me and said I owed them X number of dollars for my house. I said, I don't owe you anything. You guys are in bankruptcy. So they had allegedly sold the loan to Chase. So I'm in court fighting Chase. And now I just said that I had a process that I use to help people gain their house without a mortgage. Well, all of a sudden my process doesn't work. And I'm scratching my head saying, did I do something different, or how did I miss that? Well, guys, I'm gonna tell you, she's now my ex-wife's mother was a judge. And so I'm sitting around the house scratching my head, and they're staying with us because she started to have an Alzheimer's. So I said to myself, I don't know what this is. And she says, ladies and gentlemen, my mother-in-law is a judge, said, you better check those judges. And I said, huh? She said, you better check those judges. I said, okay, I don't know what that means, but let me look into it. So what I did was I took the judge's address and I put it in MERS. And when I put it in MERS, this judge's address came back with 34 HELOCs, home equity lines of credit, that were active. And I'm scratching my head saying, how in the world does this work? So I started looking a bit further, and I started helping somebody in California there. And they told me about a female judge in San Diego that was just a terror. So I put her address in MERS, and she had 37 or 38 mortgages the same way. So I'm like, okay, this is a pattern. This isn't good. So I looked again in Colorado, found another judge in Colorado, had a ton of them. And then I found a judge out in, I think it was New Hampshire or something. He had 27 or 28. So in the back of my mind, I'm saying, this is the way the bank is paying these judges off, because there's no way, ladies and gentlemen, there's no way a bank can win 100% of their cases. They just simply, it's impossible. It's just flat out impossible. So I started scratching my head, and I started digging a little bit further. And finally, I had about 5 judges across the country that had all these HELOCs. So I asked my mother-in-law, I said, what do you think? She said, if I were you, I'd give it to the FBI. Well, I go to the FBI and said, hey guys, we got a problem here. We need to figure out, what are you guys going to do with these judges? You got all these HELOCs, and they're ruling in the bank's favor 100% of the times, and the bank does not have their stuff together. That's where it started, ladies and gentlemen. 2 weeks later, the same guy that I give this information to is an FBI guy named Kufo. I don't even care. Next 2 weeks later, he and 6 other FBI guys descend on my house. I'm out of town. They stick a gun in my wife's face and have a 24 count indictment for me, from everything from, let's see, money laundering, wire fraud, mail fraud, bankruptcy fraud. I mean, it was identity theft. They just had a ton of stuff. And it caught me off guard because I'm like, wow, I don't remember doing any of that. So now the same guy comes to the house and I'm out of town. So at 6 o'clock in the morning, my wife's getting ready to go to work, and they break the screen door, but they wouldn't tangle with the great big door in the house, because if they break it, they got to buy it. And they weren't going to tangle with that big door because it costs a ton. I used to sell medical devices years ago, ladies and gentlemen. I had a really good job. I lived on a 10 fairway of a golf course, and all that money came from me being in medical sales, right? So that's where that money came from. But I had about $90,000, $80,000 in my bank account, and the Fed said I must have gotten that money illegally. And I'm like, yeah, right. And so I just kind of laughed. I just chuckled. Actually, I'll just tell you where that money came from up front. My mother passed. She was a superintendent of a school district. She'd been there 40 years. She left her kids an inheritance. I'm one of her children. That's where the money come from. So let's not get that twisted. But I didn't tell that initially. I just kind of let them think what they wanted to think. So they indict me. I come back into town. I go down there and I turn myself in, because I'm like, guys, if there was an issue, I was just here 2 weeks ago. If there was an issue, why didn't you pick up the phone and call me? So they take you in there and they want to put you in an orange jumpsuit and lock you up overnight and try to intimidate you and scare you. And ladies and gentlemen, I ain't no punk. I'm big enough to go bear hunting with a switch. So when they put me in jail, everybody thinks about all the bad things gonna happen. I mean, I clean this whole jail cell out. Somebody taking with me. I was angry. I was angry because I didn't do anything. And so this was in, let's get this straight. This was March of 2019, 24 count indictment. So I'm trying to sort out where this is coming from and what this is all about. And I actually don't catch it until last month, about a month ago. They come at me, we go through this whole process. They have a 24 count indictment, and they keep this 24 count indictment in place for 3.5 years. So the judge gives me a public defender, and I tell him, I don't want no public defender. I don't need anybody to speak for myself. Oh no, you gotta have one. No, I don't want one. So he forces a standby counsel on me. I'm like, ooh, don't like this. So she starts harping on this money again that's in my bank account. I said, why are you worrying about the money in my bank account? Well, they are saying it had to be illegal. I said, man, it ain't got to be illegal. You just don't know where it came from. It's all right. Just leave it alone. So finally, after a month of her harping on it, I finally said, it's my mother's inheritance. So you want me to give the death certificate and bring in the the contract and all the stuff where it came from? When I told her that, she went and told the prosecutor, because within 3 weeks, they dropped all 24 counts and came back with a 2-count indictment. Let me back up, excuse me. The indictment that they brought the 24 counts on was defective on its face. It was a defective indictment. The reason why it's a defective indictment, my name is Lorin, Lorin. My middle name is Cal, Kal. My last name is Buckner. This indictment they bring to the house is made out to Lorin K, Mrs. Lorin K. Buckner. I'm like, I'm pissed. First of all, you calling me a girl. That obviously has, this indictment obviously is defective and not for me. But for 3.5 years, they leave it in place. They don't change it. They just stay with it. Now, I filed motions to dismiss for speedy trial violations. I filed motions to sever the whole 9 yards, because they put me in there with a bunch of other people I have never met, never talked to, never had any contact with in my life. And they just lumped everybody in this thing and saying you all in some kind of conspiracy. I'm like, I never met these people. I don't know what you're talking about. But anyway, so we go through that for 3.5 years. And then they just all of a sudden, once this attorney discovers, when I tell her where the money comes from, all of a sudden the 24 count indictment goes away in the 3rd year. And they come up with this 2-count indictment of, bankruptcy fraud and wire fraud. And I'm like, okay. So we go to court, and I play dumb like a fox. I just play like I'm stupid 90% of the time. So what I did was I go to court and I give this attorney a document saying you guarantee to protect all my constitutional rights. And I tell her she's got to sign it. and she won't sign it. She said, well, I'm appointed by the judge just as a standby. I said, ma'am, if you sign this document, or don't bring your butt to court. I don't care what he says, what you say, or what they say. Either sign it, don't come to court. She said, I'm not signing. I said, well, don't come to court. So now we go to court, and this is a trial, ladies and gentlemen. The judge says to me in the courtroom, he says, hey, Lorin, nobody's going to sign your contract. I said, oh, really? I said, well, that's interesting. I said, you know, I'm kind of curious. What contract are you referring to? Well, the contract you gave to, I guess her name was Stephanie. I'm like, okay. So then I say, well, Judge, I just have one other question. I'm not sure about this. I'm not really positive, but didn't you all just violate attorney-client privilege? I never said it was a contract. I said it was a document. And it was a private document between me and my standby counsel. How did you know about it? Does that mean it's immediate mistrial for violation of attorney-client privilege? The judge went to stammering and getting pissed off and mad and starts yelling and screaming. I'm like, do we have an issue here? I want a mistrial. You just violated attorney-client privilege. I never said a word about a contract. I called it a document. The only reason you called it a contract is because it says contract on it, which means one or two things. Either you saw it or she told you about it. So he asked for a recess. They took the rest of the day off on that one. They just like, wait, let's get out of here for a day. We'll reconvene. So we come back and another, and I'm just going to give it to you straight, mistake I made. We had a trial by jury. You never want a trial by jury. You got 11 people that don't have a clue, 12 people that don't have a clue. And all the prosecutor's ever going to do, ladies and gentlemen, is pick one thing and hammer it until you're sick, till these people believe it's the truth. They're going to pick one thing and just stay on it until those people believe, oh, you must have done it. Not once have they talked about what the elements of wire fraud is. What is the element of bankruptcy fraud? What do they have to prove? Where are the facts? They had no facts and everything was circumstantial. Everything was circumstantial to the point where one of the witnesses they brought up worked for me for about 2 weeks. And then she left. She stole my laptop, took my intellectual property, stayed in our house for 3 more years. Then she turns around and emails this stolen information to the FBI. Now that in and of itself is wire fraud. You receiving stolen property. I asked them about that in the trial. Everybody looks at me like, you know, what are you talking about? I said, hey, she stole my computer and emailed the stolen information to the FBI. What are we calling that? Judge, you know, didn't answer. Guys, when you box them in a corner, the judge nor the prosecutor will answer you. You have to stop the court, stand your ground, don't move forward, and make them answer it. If a judge denies your motion, you ask for findings, facts, and conclusion in law that you use to deny my motion. You're going to have to stand your ground. So when I ask for these questions, the judge just goes silent. So then I say, Judge, you must agree by acquiescence, which means agreeing by your silence. There again, we have another recess. I'm like, what is with these daggone recesses? So we go on and they bring an FBI guy up from New York, put him on the stand, and I asked him, I said, did you interview all these people? He said, yeah, I interviewed all these people. I said, what about this one woman named Amy, whatever? Oh, no, I didn't interview her. I said, excuse me, didn't I just ask you in the beginning, did you interview all these people? And you said, yes, now you're saying no. How many of these people here did you interview? You're in New York and they're in Ohio. How many of the people in Ohio have you interviewed? Well, I didn't interview, I just read the reports. Oh, wait a minute. So this is all hearsay? Where are the facts? The judge goes by that. So we go through this whole thing, people, I'm gonna cut to the chase. We go through this whole thing and they find me and this co-defendant and my nephew, I could just, ladies and gentlemen, I could just, if I could find him right now, I could just grab him around his neck and choke him. My nephew let them talk him into taking a plea bargain for wire fraud because he sent an email with blank bankruptcy forms in it. He sent a woman an email that here are the documents you're going to need to file bankruptcy. They were blank. They were not filled out. They were flat out blank. They said that was wire fraud, and he took a plea bargain on that. And I've never been so angry at someone in my life. But here's what they do to you. The feds try to get in your head and scare you. And they spooked him. They got to his mother and said he could go to jail for 15 years for this. He better take the plea bargain. I said, none of that's true. None of that's true. The biggest fear that they have is putting you in jail. And once you get comfortable with going to jail or not going to jail, they don't have any more control or power over you. They want you to have an attorney because they take away your power, right? They're not gonna let you do what you want to do. Me, I don't need an attorney. I don't need to speak. I don't need anybody to speak for me. I'm competent enough to handle my own affairs. I'm an age of majority. There are a number of things that you can say and do. So here's where we are today, ladies and gentlemen. We go through all of that. This happened in December of 2022. You know, here we are about to be May 1, and the judge has not put his official ruling on the record yet. He's actually violating our due process because we can't even file an appeal until he puts the official ruling on the record. But once he puts the official ruling on the record, he's like, you know, Lucy, you got some explaining to do because you had 3 opportunities to dismiss it. And the judge kept saying, it's not in the public's interest to dismiss it. And ladies and gentlemen, at that point in my life, I was like, you got to be kidding me. So I asked the next question. And all I want to do in here is ask questions. I don't answer none of their questions. I said, what is the public's interest? Don't take their word for it. Ask them point blank if they say, well, it's not the public's interest. What is the public's interest? And are you over the public trust, Mr. Judge? The public interest, as I found out later using that QSIP research, it was $258 million that they had lined up on his case for 3.5 years. That's the public interest. That's what the public interest is. It's in a QSIP. It's and they use bid bonds, performance bonds, and payments bonds. So where I sit today is I'm waiting on the judge to make a ruling so that I can file for an appeal. Now, if I don't get an appeal here shortly, I'm going to do a show cause hearing in Washington, D.C. because my nephew tried to file for an appeal here in Cincinnati, Ohio, and the appellate court said they don't have jurisdiction because there's no official ruling on the record. So I started doing research like most of you people would do to try to figure out how long a judge has to put the ruling on the record. And they can hold the ruling almost indefinitely. I've not seen any specific date, 90 days, 120 days, year, whatever, I've not been able to find anything. And I trust me, ladies and gentlemen, I get up and go to the gym in the morning. I leave the gym, come home, shower, and I go right over to the UC Law Library, and I spend the rest of the day over there looking up cases and trying to figure this thing out because it's my life on the line. They're trying to lock me up because I've discovered that the banks were paying the judges with HELOCs. And so now they have to discredit me and get me out of the picture. I kind of stumbled into it. I really wasn't doing it for any other reason than my house was in foreclosure. The judge had a number of loans with Chase Bank. My house is with Chase Bank. I even asked the judge to recuse himself. He wouldn't do it. To tell you how fraudulent and deceitful they are, they couldn't make the 24 count indictment stick, so they had to get out of that one and go into this 2 count indictment because they felt like they could make that stick. So they got this guilty plea. I'm sitting and waiting on the judge to make the next move. And I've been sitting and waiting since December 1st for him to make a ruling so that I can file for the appeal. They won't even take me to sentencing. They won't do anything. That's pretty much the gist of it. And I've been traveling around helping other people and learning from other people. I took the, I don't know if you all have it. If you don't, get you a copy of the little book, The Constitution. I was in a court in New Jersey earlier this year, and I was sitting on the back pew, and I just had the book out, open it, out in court, kind of reading it. The judge called the bailiff up and told the bailiff, tell me I don't need to stick the Constitution in her face, so put it down. I said, wow, does it scare you that much? I I said, yeah, I get it. And I didn't put it down. I just put it down for a second. I put it back up. I'm like, if it bothers you, I'm gonna keep doing it. That's just me. You don't have to be as antagonistic as me. He goes, I'm just kind of dumb like that. So that's pretty much it. Richard has known me. I don't know Richard, but we've probably been, we've known each other for, I don't know, 5, 10 years, maybe longer than 5.
Quite a moment.
Yeah, it's been a while.
Yes.
And this is the journey and the path I'm on, folks. And I'm not gonna give up. I don't care what they say, what they do. I'm gonna stand on my square 24 hours a day, 7 days a week. I have brothers and sisters that have tons of resources. And when I tell you they got tons of resources, they got tons of it. Everybody in my family is a postgraduate degree. My grandfather graduated from Ohio State in 1916 with a degree in pharmacy. They wouldn't let him be a pharmacist. My family has resources. I would not use or take any of their resources, nor allow them to be drugged into this thing, because it's all false and frivolous. And I wasn't gonna let them tarnish my brothers and sisters. So I'm in the journey by myself, and I'm good with that. I scrap better by myself than I do have to worry about somebody else. My wife and I got divorced. I lose my house. They want to kill your reputation. They want to make sure they tie up your money. And they did close my bank account with my money in it. And so for about 6 months, I was flat broke. Wow. But I figured it out. I hustled. I worked at it. You do what you do. Help some people along the way. And I'm in a much better place. I'm just waiting on these people to make the next move. I know most people don't understand this part. There's a ruling on the book that says they have to pay you $3,000 a day for every day they basically have you incarcerated. Well, this entire case has had me incarcerated, so they owe me $3,000 a day for 4 years. So we will get to that and get that money. The bonds that they use, they take the bonds and they trade them with the Federal Reserve, and they get 10 times the value. So on the 258 million, that bond probably turns into $2.8 billion is how they make their money. So at that point, Richard, I'll stop. I don't want to, I'm sure a lot of people have questions.
Yeah, if there's any questions, raise your hands. And then Gavin will go ahead and put them there.
Let me just start with your sentencing, Lorin, because clearly that's your next step. So it looks like you're going into the sentencing, and I'm obviously you're spending day and night in the law library. So what is your plan going into that?
Well, my plan to that going into that, prior to doing the sentencing, I'm going to file a motion to stay and do a show cause hearing in the federal court in DC, because I'm not going to get the appellate court here to move forward because they're saying they don't have jurisdiction. So in essence, what I'm going to do is I'm going to prosecute the prosecutor. I know you all heard of that. I'm just going to prosecute the prosecutor. There's some questions that she has to ask, like, does she have a foreign registration statement on file with the Justice Department? Does the federal government have jurisdiction outside of 10 square miles of Washington, D.C.? There's a number of questions she's going to have to come to court and bring evidence. I'm not interested in what her mouth says. She's going to have to show it to me. So my thing is to file a show cause and then put a stay on the sentencing until we get the show cause done.
Okay, real quick, like then, when you were saying the Foreign Registration Act, okay, why are they supposed to have that?
Okay, what I don't do, and good question, what I don't do is give them their statutes and code, but that's under 22 USC 611. That's under 22 United States Code 611. I don't use their statutes and codes in there because I'm not one of their people. So I just ask the question: do you have your foreign registration statement on file with the Justice Department? Let them figure it out.
Yep.
Don't put the statute in there. Let them figure it out.
Absolutely.
And so when you ask them about the Constitution, they'll say, hey, do you all have jurisdiction outside the District of Columbia or 10 square miles? Show it to me. It's Title 18, the one that always come after us with Title 18. When was the last time Title 18 was ratified? It was 1948. In 1948, there was no wire fraud and mail fraud and bankruptcy fraud in there in 1948. So how can you now say that is valid? Show it to me. Don't tell me about it. Show it me. I have friends that have gone to DC down in the archives looking up Title 18 to see when it was last validated by Congress. 1948.
Wow.
Let me, Lauren,
Yep.
just one quick story that might help you on the set. Well, I know will help you. I have a close friend of mine, Chris. He's a chaplain, and he, this is obviously a different case. He went for a misdemeanor, in state court for practicing contracting without a license. He
Gavin,
filed all the.
we should hold that to let, if they've got other people that want to ask
This
questions.
is right. This is totally right on point with this sentencing. Trust me, it'll be really
Okay.
quick. And I'm going to share this with you, and you can run with it because I know you'll research it. All right. This is a life-changing, really quick story that you.
Okay.
He went in for sentencing. He lost at jury trial, just like you did.
Mhm.
Lost. Case over. He knew the law so well that he knew that when he went in for sentencing, it was going to come down to consent. He raised what's called the Model Penal Code. I've got a copy of it. He gave it to me. Model Penal Code. You can pull it up and find it. I have a copy. I can send it to you. It says right in here. Model Penal Code requires consent. I thought this was some sort of a wives' tale. It's not. It says once the defendant consents, they sentence. He never consented, case dismissed. They slammed the gavel down. He walked out right when the jury was there. It says this: provisions of this code, according to a defense or mitigation, shall apply, comma, with the consent of the defendant.
Wow.
Okay,
Okay.
looks like Richard's iPad.
That's Deb.
Yeah.
Yeah.
Hi, guys. Hi, Lauren.
Hey, how are you, Deb?
Good. Thank you. I listened to you last time you were on. I think that was about a year ago. Thank you for coming on. I came into this a little bit late, and you were talking about the work you've done against Washington Mutual. I just wondered if you could reiterate that, just the beginning, if you remember.
Okay, so I'm working with somebody else. WAMU gets it, and WAMU is in financial trouble. They're done. They're literally done.
2008?
Yes, they're
Right.
done. So I'm asking questions as it relates to, wait a minute, if you're bankrupt, what are you selling? What do you have to sell? What is JP Morgan Chase buying based on not the comptroller of currency? The banking finance people are saying JP Morgan Chase bought all of
Right.
WAMU's debt. And I'm like, well, prove, show it to me. Don't tell me, show it to me. So I'm in the lawsuit. We're going up and down the road. And so we're fighting it out in court. And I finally get them to the appeals court. And let's see, this is about the 5th law firm that they got. They went and got, I can't think of this one law firm. It's a really big one. They got offices in Ohio, Illinois, New York, LA. They are down in Florida. They're all over the place. So they went and got the biggest and baddest they got and just pulled a little me. And I act like I'm poor, dumb, and stupid. I backed them in the corner and said, guys, all you have to do is just present the original note. Unless you've already, sold it to the federal, exchange it with the Federal Reserve for 10 times the value, and you don't have it. Or then it showed, Washington Mutual showed that they had taken and not collateralized, but they had written the debt off. Washington Mutual showed on their books they'd written the debt off.
Right.
So at that point, I'm like, well, the debt's extinguished. So I'm in the appellate court talking about a debt being extinguished. What exactly? What I said was, what exactly does that mean? And so all the attorneys and the judges and everybody looking at me, I said, what does it mean? If it's written off, have they taken a tax benefit? Are we double dipping? They've taken a tax benefit. Now they sold it to someone else after they take the tax benefit. Where's the original note mortgage? And I know that, the original note has already been exchanged with the Federal Reserve for 10 times the value, and the bank's been pretty much paid. So I'm beating up on these guys. They can't move forward. They're stuck. And all of a sudden, out of the blue, the judge that I'm referring to, judge was Powers, I think was the guy's name, was the judge I had for my foreclosure case. He's just gonna arbitrarily rule in the favor of the bank. Well, wait a minute. They don't have their stuff together. We've not come to any kind of resolution here. And so he says, well, I'm going to rule in favor of the bank. I said, okay, give me the findings, facts, and conclusions in law that you use to arrive at that motion. He said, well, the court's going to use its judicial discretion. I said, that's your own person. That's your own personal. That doesn't do anything for me. Show me the law. I don't have to show you the law. You know, now he gets very defensive. I don't have to show you the law. If you ask me another question, I'm gonna hold you in contempt of court. I'm like, wow, that's interesting. Is that gonna be criminal or civil? I said, because if it's gonna be criminal, it's gotta be injured party. If it's civil, it's gotta be a contract. Do we have a contract? Oh, you want to know smart ass? Hey, I'm asking questions. Am I allowed? And so we go back and forth, and he slams the gavel down and says, well, it's done. And I said, I don't think so. And so I filed for another appeal. We take it to another appellate court. And I got my foreclosure case hung up. This thing went on for 15 years. Literally, it went on for 15 years.
Wow.
And finally, my wife said, Lorin, I'm tired. It's like, well, I'm not. I'm having a pretty good time here. I'm not tired at all. She says, I'm tired. And so my wife wouldn't help me anymore. So I kind of got stuck with trying to do it all myself. And the reason she didn't want to help, her parents had left her this big fancy house paid off. I told you her mother was a judge, her father played pro football, and they had a bunch of money. So parents left her house. She just wanted to go home and live in the house. And I get it. Ladies and gentlemen, I get it. We all have spouses or whatever's, and we fight a different fight than they're used to fighting, and they don't believe in it. And so there's a number of people that go their separate ways because we just have a different ideology or thought process.
Right.
Yeah. So that they got my house because my wife wouldn't help.
Yeah, I wanted to bring something to you that I've given to Richard, and I've talked about it before. In the Washington Mutual bankruptcy filings, the court's final examiner's report, it's court ordered. Mm-hmm. It states by the examiner that every asset that Washington Mutual had was sold in a blanket lien to the private bank in San Francisco 1 week before the FDIC receivership. Oh, wow. So the FDIC never got anything and Chase never bought anything.
Wow.
And it's in the bankruptcy filings. Okay. And I can send it to you if you'd like.
Yes, I love it.
Yeah, it took, do you know who Bill Podolo is?
I know, yes.
It took him years and years and years to find this, and he found it.
Yeah. They don't make it easy for us.
No. So, and then I heard you talking about, you found out that the banks are paying these judges out of HELOCs.
Yes.
Okay.
That's what got this case started. As I said, I had a process that worked really well. Like I said, 8 or 10 people that have houses didn't have mortgages. And then all of a sudden, when I get to my house, it doesn't work. I'm like, why does it doesn't work? What happened? What changed? And I told you my mother-in-law, who was a sitting on the bench judge, started to have Alzheimer's. So they were living at our house. And she said, you better check the judges. So when I put the judge's address in MERS, Mortgage Electronic Registration System, it kicked back 37 mortgages for this one guy, Powers. And that woman in San Diego, I cannot think of the judge's name in San Diego. It was a female judge in San Diego, because I remember giving the FBI that one guy Powers' name, and the woman from San Diego, and the guy in Colorado, and the guy in New Hampshire. I'm trying to find my old big desktop computer to pull that data back off of it. Those were the people I presented to the FBI. And then 2 weeks later, they came back at me and said, basically, you're going down.
Right.
Sorry to interrupt, but is the judge in San Diego by chance Judge Ipema? Tamala Ipema? IPEMA?
I'm sorry. That sounds familiar. I think that is her.
Well, if you can confirm that, I'd like to know that.
Yeah, let me look and see if I can find that data. But I'd given that information to the FBI, and they just turned around and came back after me 2 weeks later, and they want to indict me. And
you believe it was retaliation of some kind?
No question. And what I found out about a month ago it's a whistleblowing is now for me is why I'm not panicked, everybody. I now know it's a whistleblowing. I blew the whistle, and this is retaliation for me blowing the whistle. There's no question about it. There are things that are just too close together. They don't make any sense. And the interesting part about this is the one guy, the linchpin for all of this, holds it all together for the whistleblowing is the FBI guy named Kufu, who I gave the information to on the judges. 2 weeks later, this is the same guy that stuck a gun in my wife's face. I said, wow, that's interesting. That almost creates a conflict of interest in and of itself. I give you the information, then you turn on me. Find that interesting.
Modi, you got your hand up, buddy.
To what?
Oh, Modi has a question. He's gonna
Oh,
ask
okay.
you something. Modi.
Yeah, I was gonna say, I don't know if you've heard of this or not, but I know Deb was bringing up an interesting point about what they done where they sold the assets before the FDIC had a chance to do that. I've done some research on that too, and those regulators don't like that, and they're supposed to be able to come back. If anybody's done that, taking assets away from the bank, they go after them to get it back. So I don't know who's in charge of that to do that. But if you check into that, those bank regulators are supposed to go back. It doesn't matter if it was 6 months before or 3 days before. They want those assets to pay off debts. So you might want to check into that too, if it'll help. I'll view
Well,
this
the bank that it was sold to, Modi, is the Federal Home Loan of San Francisco. Each state has a private bank that's government owned that helps fund, it's put there to fund banks in that state. And that's where WAMU sent every asset. They sold everything they had in a blanket lien. And in the examiner's report, it goes on to the states that Chase was allowed into WAMU's documents room, and they were acting in bad faith. So Washington Mutual didn't want Chase to have their assets. So that it was a very intentional move to make sure Chase didn't get their assets.
Nice.
There's a bank regulator for every state, whatever that state occurred in. That'd be where you need to go.
All right, raise your hand, everybody, one at a time. Modi, you're still up.
I'll mute myself out. I just want to throw it in there, see if it would help anybody.
Okay.
Thank you.
Thanks.
Anybody next?
I make a question. I've known Lorin for quite some time. This is the Love Monkey again. And he come here and we talked about courtroom procedures and stuff like that. And what I want Lorin to express that when he went into the courtroom, when you went in front of these courtrooms all the time, did you tell him the law or did you ask questions?
I just ask questions. I don't want to make a statement that I'll have to defend later. So I just simply ask the question. I don't, and ladies and gentlemen, I don't ask a question unless I already know the answer.
How does that work?
What do you mean? Okay, so let me give you an example of people I've helped and how this thing works. Let's say you go into court and the judge says you got to go to an arraignment. The judge says, "How do you plead?" And you kind of say, "I don't have enough information to plead." The judge says, "Well, we're going to put a not guilty plea in for you." I teach our people to say, "Thank you for that, judge. As long as you know you're going to be my attorney throughout the trial." He almost comes unglued. He gets, "Oh, no, that's not how it works. No, wait a minute." What you've just done, you've done two things. You told the judge, first of all, he can't practice law from the bench. And then you put him in an implied contract that he cannot perform on. So they're going to have they're going to do everything they can to get out. No, I tell you what, we're going to continue this and get you an attorney. Thank you for the continuance, judge, as long as you know I'm not waiving any of my rights. All right. So if the judge said, "I'm holding you for selling drugs or something." "Oh, okay, got a case in Indiana. Lovely case in Indiana. Okay, we're bringing you in for selling marijuana." I'm like, "Interesting." I know for a fact in the state of Indiana, they don't have the test equipment to test for THC. So you don't know if you got hemp, marijuana, weed, you don't know what you have. But they want to make a case based on that. So we used to ask the question, Judge, what is that substance you're referring to as marijuana? What is that? And by the way, what is the THC content in that? Now, you all say, well, Indiana could go out and buy it. No, they don't want to go out and buy their test equipment because the state of Illinois has legalized it to the west, state to the west. The state to the north, Michigan, has legalized it. And then there's a law in the books called full faith and credit. It says if a law is good in one state, it's good in all states. It's called full faith and credit. So they're not going to spend $40 million to buy test equipment to have their Senate in 2 weeks or a month decide they're going to make it legal. What are they going to do? How are they going to justify the $40 million spend on that test equipment? So the legislators are like, well, we ain't going to touch that right now. The judge even said he didn't like the position that they left him in because now the judges have to try to make that determination. So we just ask questions. Judge, what do you have?
They have to have the facts and conclusions. They have to have the facts and the evidence to support that fact. And it has to be admissible evidence. You know?
So, and we also give what we normally send out is a bill of particulars. We send that out early to the prosecutor and ask them to answer some questions. Now we've yet to get an answer. It will drag it will gum up the case to the point where, you know, you go to court and the judge said, well, if you get it in before your arraignment, and the judge says, how do you plead? Well, judge, as soon as I can get the answer to those bill of particulars, I'll be more than happy to plead. When can I get the answer to the bill of particulars? Now you're on offense. When can I get an answer to those bill of particulars? There's only 37 questions. Of the 37, there's only 2 of them that rattle their cage and they don't want to deal with. 2 of the questions asked, well, one of the questions I asked, are you reporting this on a 1099 to the IRS?
Absolutely.
You know, are you making money and are you reporting to the IRS? Those are the 2 questions they don't want to answer. Not in open court.
Did you make a bill of particulars demand? And if so, what they do with it?
Oh, well, the prosecutor always run behind the judge's robe and try to get the judge to deny it. And so we have to go at the judge and say, Judge, that, you know, you're denying something that wasn't sent to you. We gave you notice. Unless you can tell me how, Judge, give me the findings, facts, conclusion law that you use to deny a notice. It's not a discovery request because it clearly says not discovery request. It's a notice. Judge, how do you deny a notice?
Huh. Debs, you're up. Got a question?
Yes, Lauren, can you use that bill of particulars in a foreclosure case against
Yeah,
the other side and the judge?
Yeah, well, you know, there's a way to go after. You're talking about the attorneys, because the attorneys are the co-conspirators in the actually
Right.
in a
Right.
foreclosure. It's not the bank signing anything, it's the attorney signing the document for the bank.
Right. Right.
You know, you're gonna have to put them on the hot seat. You're gonna have to say, you know, Richard does it, you guys do it better than anybody. Richard say, okay, is that a verified complaint? Well, show me how you verified it, Mr. Attorney. You're not a first-hand material fact witness, are you? Then how are you signing a complaint as the complainant? How are you doing that? I'm not sure. You know, I play stupid. I'm like, I'm not sure. How does that work? Can you help me understand that? I mean, what are you suggesting here?
Are you a witness or an attorney?
Well, if you're a witness, let's get you sworn in here. Let's go. Now you start telling the judge and everybody that you want to swear in the prosecutor. Oh my God, the court's going up for grabs. Oh no, we don't do that here. Oh, what are you trying to say? If they're gonna give testimony, swear him in.
Richard has a strategy for that.
Yes, he does. Yes, he does. So that's, you know, you're gonna have to go at the attorneys. You know, you're gonna have to go after the attorneys. I have one going right now where I just sent the attorneys a letter last week. I said, dude, you got 15 days to resolve this. Well, I'm gonna report you to the postal inspector for trafficking in fraudulent securities.
Woo.
And I give them all the codes. Here you go. Enjoy this.
Could that work for the
Modi.
case?
Yeah, I just remembered something else too that might help. For the FARA thing, for $96, FARA will take take an application and do the research to see whether or not that attorney that you're talking about, whether or not he should be registered underneath the FARA, if that'll help you. And then
Yeah.
also too, there's a gentleman named Robert Fox. He's passed away, unfortunately, but he brought up something to me about court. And he was in federal court quite a bit. And one of the things he brought up was, he said, after the sentencing, if it comes to that, and I hope it's not, I hope you're just going to get it dismissed. But what he brought up was, he said, there's a little small moment in time to where, you know, what they're going to do is they're going to announce a sentence on you. And then they're going to ask you to speak. They're going to give you, it's called elocution, I think is what it's called. And he told me, he said, what you do is, it kind of goes along with what Gavin said. And what he said was, he said, there's just a little point in time. What have you got to say in defense of yourself? And that little time, what you say is, I am innocent of all charges. I've got nothing to do with this. You haven't got no proof that I've done it, and I'm denying it. I'm not.
No, I don't consent is the magic
I
word.
don't consent. And that's it.
Patsy.
And that, he said that will walk you out every time, just like Gavin just said.
I would never believe a word of that, Modi. I'm a statutory, I just do the statutes like
Sure.
Richard, but now that I've read it in the model penal code and the law itself, it has credence. And when my buddy Chris told me the story of how he got off on his case at the very end after losing at trial, I was like, oh my gosh. Whoa.
Robert Fox said the same thing, what you just said. He said it a little bit different, but it's the same effect. And what he said was the same thing what you said. But it's called elocution, I think, if I remember the term right. It's that little window of time that the judge will give you to speak. And that's it. And I'll shut up. Sorry about that.
Oh, you fine. It's all good.
JD,
Yeah, well, Lee Harvey Oswald did that same thing, and then he got shot by you know, what's his guy's name? Jack Ruby, you know. He says, I'm just a patsy, and they shot him. But yeah, no, I hear what you're saying. I was gonna ask you a question with regards to if you can use this I guess quote unquote whistleblowing or you know, exposing on any sort of case, or is it just you know, when you talk about taxes and stuff like that, is it just a foreclosure case? Or
No,
could
you
do it on
can use
other-
it anywhere. The whistleblower, you can use it anywhere.
So
Anywhere.
they're all using
Uh-huh.
the taxes and everything, right?
Yeah, the taxes are easy. They're easy. The IRS has to do it only one way because they're so big. If they start deviating, they got so much to clean up. And all it is, guys, I mean, it's nothing but an accounting issue. It's just all the contract. It's all pluses and minors, basically. That's all
And
the
when-
IRS is.
And when you went and spoke to the FBI and they kind of like turned on you, I guess, or they, you know, wanted to shut you up. I mean, is there certain places that you suggest us not to go and you know, expose, you know, or tattletale or tell or
Well,
know,
I think you
with the
got to
world?
be strategic and tactical. Basically, you got to be smart with it. One of the mistakes I made, you know, the big mistake I made, I went by myself. I should have taken 5 or 6 other people with me. Now they got a problem, right? You're gonna come after 5 or 6 people, and we all gonna have the same story, and we're all out, you know, we're all gonna put this on Facebook and blast it out to the world. That would have created one of the problems that we all have. Everybody on this phone that goes to court is we don't take anybody with us. Well, I've learned my lesson. I always have somebody with me whenever I go in there. I got friends and buddies that I that I take with me everywhere I go.
All right. Okay. So do you mind just maybe giving us a little bit of I know you said a little before, but just a rundown of where, you know, where the strongest or the most effective agency was for you, or what you can suggest for us to go if we want to go ahead and expose?
Well, I went to the FBI. You know, if I had to do it all over again, I'd probably go to like the Attorney General or the local. See, because actually, you know, if you take it to the FBI, they're going to take it to the local DA, So you might want to start with the DA. Say, hey, let's talk hypothetically. I got this issue. How would you, Mr. DA, address this issue that I have? You know, is a way to approach it and see what they come up with, because the DA is ultimately the person that's going to have to sign off on it. You know, I'm going to ask questions in this show cause hearing. Did you all have did you impanel a grand jury? If you did, give me the transcript. You'd be shocked at how many times they do not impanel a grand jury and tell you they have.
Yep.
So I'm going to ask some hardcore questions in the show cause hearing, and the prosecutor is going to have to answer.
And Lorin, did you go down the road of looking at the actual jurisdiction of the federal government over private people and states under the 10th Amendment? I mean, I don't think there's any case authority on it. It may be a wild goose chase, but have you already been down that path?
Yeah, we
Where do they
looked
get
at
their jurisdiction from?
Well, yeah, and that's one of the big questions. Do they have jurisdiction outside the District of Columbia and 10 square miles? The Constitution says no.
No, Puerto Rico.
Well, raise your hand,
They
please.
say no.
So have you been down that? I mean, obviously, yeah, the Constitution says no, but you know, I've got another Dan Bailey, who was a colleague of mine. He's gone around and said, we can't find any authority on that. So could be a dead end. But
Yeah, I have something on it. I got I paused for a second because I was looking for my duffel bag, my backpack. I have it's called Territorial Jurisdiction, Article 1, Section 8, Clause 17 of the United States Constitution. Congress should have the power to exercise legislation in cases whatsoever in the District of Columbia not to exceed 10 square miles. That's Article 1, Section 8, Clause 17 of the Constitution.
Yep, territorial.
Yep.
and then based on the 10th Amendment, all of the powers are left up to the state. So
Correct. And the way I remember that, believe it or not, is if the United States has jurisdiction all over the United States, then that means every state has jurisdiction in Washington, D.C. It's a reciprocal thing. They're not going to do that. Right? They're not going to say, okay, states, we rule over you, but you can come to DC and rule over us as well. It's not going to be reciprocal.
So when can you take it to the federal?
I'm sorry?
When can you take it to the federal court? Then when
JD,
does that?
Wait till you're called on him. If you
my
got
bad.
your hand up, he'll call you.
Okay, the hands up. Okay, my bad.
Yes. Go ahead and call him, Gavin.
okay, JD, you're up, buddy.
Oh, my bad. I just sometimes I forget that I'm like, you know.
That's cool.
I apologize. So when would the federal courts be evoked, or when could we actually take cases to the federal level if we're not living in that territory? I guess, you know, in a sense.
In a sense, I'm going to the appeals court in Washington, D.C., and I'm prosecuting the prosecutor. I'm just bringing the prosecutor in under a show cause hearing to answer some questions. And there are about 30 of them I got written down. It's called, you can do a show cause hearing, or you can do a motion to dismiss for lack of territorial jurisdiction. I had the document here in front of me.
Is that a writ procedure?
Yes, you can do a writ of.
No, are you going into the Court of Claims?
I'm going to appellate court of the United States, because they're going to say, and what they normally do when you do that, they'll say, well, you exhausted all your remedies in your local jurisdiction. In the local jurisdiction, my nephew went and tried to file his appeal, and the local jurisdiction told him they didn't have, the appellate court said they didn't have jurisdiction. Then this other guy that they indicted with me, named Dez, they actually have him locked up, and he's been locked up since December, because they said he violated his pretrial something, which he never had. He never had a pretrial agreement with them, but they locked him up because he put in documents to make the judge the fall guy, and the judge wasn't happy with it. This guy's from New York, and so he put some documents in there that the judge really doesn't like.
JD, you got your hand up?
Yes, I did. Thank you for calling on me. You were mentioning, Gavin, we spoke a little bit earlier about declaratory judgment, and then Lauren was talking about show cause. Would you consider declaratory and show cause something that that could be kind of combined, or maybe doing the same kind of
Show-
effect?
Show cause is a motion, a declaratory, relief is a cause of action.
So show cause is not
It's a motion,
a motion to do what?
show cause,
Right, in order to receive,
an order,
and a declaratory judgment is the what now?
a cause of action.
In order to,
Get the court to declare something.
so you don't think they can't be combined or anything like that, or they're not the same, they're not similar methods?
Me personally, maybe Gavin's got a different role. I would not combine them. I'm kind of funny about combining stuff because, you can combine stuff and they wipe each other out.
Yeah, I agree. Well, it's a motion. You could do a show cause and a declaratory release, I guess, but I
Yeah.
don't think it's necessary. He has it, he's in a criminal case, so, he's doing a show cause for something that he believes is, he wants the court to make an order to show cause over. I don't know what was it over, Lauren? The show cause over the
Well,
Laura?
it's a show cause for the prosecutor to show that they have jurisdiction over the case.
show cause for jurisdiction. Yeah, okay.
Yeah.
That's like a writ. Yeah, some sort of an
Yep.
interlocutory appeal.
Yep. And I just put a notice of show cause hearing. Because I want to keep, I don't want to use any of their statute or codes, any of that. Here's a notice for show cause hearing. Let's get in here and let's see if the prosecutor will come in here and defend this, which they won't.
Something to drink. Oh, you got you something to drink.
Yeah, I got
Something
some.
out there, school?
No, man.
Okay, Modi, you got your hand up, buddy. You're up.
Yeah, I know, JD, I heard you talking a while ago about, none of the paperwork. I couldn't understand if you were still fighting foreclosure or not there, but I know you said that none of the paperwork comes from the banks. Some of my research, I'm down in Kentucky, so I ain't far away from it, but the research that I've done, all these law firms have an internal title company. And these groups are out here, law firms, they might be in 10, 15, 20 states, but they have an internal law firm that generates all that paperwork for Liz Pendens and other things. And I don't know if you might have checked into that or not, but that's what I found here lately. I don't know if that might help you or not. I'll mute myself out.
Please,
Well,
please.
What I found here in Ohio and over in Kentucky, the law firm that does the bulk of this is a law firm called Lerner, Sampson and Rothfuss. And they got, they have a woman there. Her name was Shelley Hill that was deposed by the federal government because she was signing documents as vice president of the bank, and she just graduated from a local high school. She was a paralegal in a law firm, and a lot of the stuff that she signed, these people end up getting their houses free and clear because she signed as vice president of this bank or that bank or MERS or whoever, and they deposed her and sanctioned Lerner, Sampson, Rothfuss and this young lady because she always had the same person notarized it. Shelley Hill was one name. I think the other woman's name was Dare, T-I-R-E. She would always
Linda Green?
notarize the document. Yeah, like Linda Green, correct. And so, all of that stuff came to light, and a lot of these banks threw their hands up and ran because they knew they were liable and could be drawn into the case. So, yeah, Lerner, Sampson, Rothfuss there.
So I'm glad you're aware of this because there's been over 50 attorneys, and I think I remember seeing Lerner Sampson in my cases, but there's been like 6 or 8 law firms come after me, and the majority of them, believe it or not, are out of Ohio. There's a few of them that got branches in Kentucky, but anyway, well, I'm glad you knew about that. I'll mute myself.
Yes, sir.
Sorry.
On another note what we're talking about these notice. I was talking to Lauren earlier today concerning a process. See, because when we file a claim or a lawsuit against whoever it is, whether it be the banks or the attorneys and things like this, they're mandated by the statute to be able to meet and confer with you. And I was talking to him about this, that see, if you don't know about something, you can claim that you don't know or you weren't aware. But our process, what we're talking about is that we build our case prior to filing our suit. And then what we do is we submit everything like that to the attorney. And then we show them all this stuff and we give them the opportunity to be able to go ahead and retract that. Okay, to be able to either sit down and negotiate with us, or because we're led to believe that his client has misrepresented material facts to him, which in turn he will misrepresent that material facts to the court in violation of his own state bar rule, which is 3.3 and then 5-200, and also California Business Trust Code 6068. Okay, so now you can present all that information to him and have him take a look at that. And then if he completely ignores that, when he goes to court now, what you can do is you can have move for an order to show cause why he should not be held in contempt of sanction for bringing a false claim before the courtroom. Okay, that can be done,
CCP 1212.
underneath 20 what you want to do is also provide him a safe harbor notice under CCP
128.7.
Yes, 128.7. Okay, and you have to stand on that. And when you go in before those courts, how do you approach it, Lauren? You go in there like a little pussycat, or are you in there to
I'm a beast. I'm not nice. I'm a beast. I ain't nothing nice. I'm like, I start out
cordial?
cordial, I'm basically trying to trap them. The thing I use with the document, if you heard that scenario, I call it a document. I know exactly what it is, but I want to trap the judge or my attorney into violating attorney-client privilege so I can get a mistrial and get the heck out of there. So I kind of set them up that way. And same thing in the foreclosure. I start out acting like I'm naive and asking questions to let them let their guard down. Most of them are not smart enough. And then I just take them apart. I mean, I stand on my square and tell them what I got to tell them.
Do you worry about the judge getting upset and mad, or mad at you? Do you
I
worry
don't care about man. Who cares about what the judge says? He's a public servant. He is to do what we tell him to do.
Absolutely.
And that's it. I'm gonna share this with you all. I probably should, but most of us have a 401k. It's our retirement. Judges have what they call an 801. So what that is every case they hear, a certain percentage of the case goes into the total judge's retirement fund. Okay, so every case they hear, there's a percentage of that case that goes into the judge's retirement fund, not that particular judge, but in all the judge's retirement fund. So when they retire, they then start paying them out of that fund, but you can't track it back to any particular case, and they do it that way. Well, people ask me, how did I know? I said, well, my mother-in-law was a judge, part one. Part two, the woman makes $17,000 a month and has for the last, 10 years from the judge's retirement fund. And I'm not talking about what somebody told me. I'm talking about the check that came to the house from all the years on the bench. For every year, she's getting it now, and she'll get it for the rest of her life. 17 grand a month. That's a lot of money.
Absolutely. And that's why I'm going to tell you, see, they don't care whether they get recused or they get kicked off the bench there, because they get that money in retirement, and this is why people need to fully understand. You think, well, I'm really scared him. You don't do any of that stuff to these guys really that much, they do get intimidated a little bit of things when you begin to know certain things, and they don't really want to lose their position in the game. But in the end, they're still going to win because they're going to receive that money until they're gone.
So they don't do it.
Did you raise your hand?
Oh, I think I did.
We don't see it. Gavin, you there?
I was wondering, Richard, when you, has things changed? I mean, have the rules and the laws changed since you won all those times in court? Do you know if they've changed the evidence code?
No, you know what it is what they do is they become more aggressive to other people. That's the thing is that, back in the day, they would really listen to you. When you followed the statute and codes and stuff like that, they would follow the law. They would follow the law. But as time went on, they knew that, I guess they got together and said, we can't have this, that they started ignoring things, they really started ignoring stuff. So but I think that you can still hold them accountable. It's the same thing as Lorin. And, today we had a win, and that's with, Ronnie and Clark. They went to court today on a case, and it was on discovery, and it was against our buddy. What's his name? Ronnie or Clark? You there?
Dennis Block.
Oh yeah, Dennis Block.
Oh, I know Dennis Block.
Yeah. See, anybody knows a lot about Dennis Block over there. So and I'm telling you that. Clark worked with Ronnie. They did because they didn't file the discovery. I mean, they filed discovery and they didn't respond, and they did some creative paperwork too, also, and put it inside there. And what happened today when you went into court there, Ronnie?
Well, I had an attorney to come there just so I could try to put this case off in case if it all went bad. I had no idea that they were going to be dismissing the case themselves. So the judge told my attorney, what do you think this is? You didn't put in a substitution of attorney? Get out of my courtroom. And told my attorney, get out of the courtroom. So, and then the lady came up and said that she was here for the Force case, that she was Qualls's attorney, and that they were dismissing the case without prejudice.
Yeah, she was a special. Go ahead.
Yes.
Go ahead, Clark.
Yeah, she was a special attorney, whatever you call it.
Yeah, special appearance attorney.
Are you saying the plaintiff dismissed his own case?
Yes.
Yes.
It's awesome.
And what grounds was that? And what was the case? What was the cause of action?
Yeah, he didn't have no evidence. We did a motion to compel on him for not answering discovery.
What was he suing you over?
It was an unlawful detainer issue, and what he did was he propounded discovery on them, and they never responded. So he put in a motion to compel and an order to show cause why they should be sanctioned, or deem it an alternative being deemed admitted. So when they did that, they went inside there, and the other side just dismissed it. Dennis Block didn't show up. He used a special appearance attorney. He said, no, we just want to dismiss it. They just let him out of the courtroom. But as an example, I want to hold that for a second, because I want to show you something, which this is what happens a lot of the times. He went into the court there, and he was looking for sanctions or have it deemed admitted for them to fail to comply with the statutory requirements to respond to his discovery. But and what happened was they dismissed it without him getting into the merits of the case, because he could say, well, wait a second, Your Honor, they failed to comply to the statute. I want my damages. I want
Costs and fees.
Exactly, costs and fees.
That's not over. He hasn't waived that.
No, he can go back inside there and that.
Next move is that, that's how I got mine, and I same thing with me, where I went into court, and I was ready to go to battle, and all of a sudden, oh, we're dismissing. Well, I want my costs and fees. You got to talk to the attorney about that. So I picked up the phone and I said, hey, counsel, either I'm going to get paid or I'm going to move the court and make them pay me. What's it going to be? And he's like, well, how much, and we negotiated a price and he paid me. So you got to pick up the phone and call him.
Yeah. And then you can tell him that you can put the motion in there for that. But
yeah, I mean, if he wants to shine you, but
yeah.
The opposing counsel knew I wasn't playing, I mean, if you're bluffing, don't call him bluff. I mean, be serious. If you're really going to move the court and make the court compel him to pay you. I actually had already written the whole motion and I had it on my email. I sent him a draft copy at the end of the call. I said, just so you know, I'm not playing. Here's a copy of the motion. Bink. And he's like, okay, checks in the mail next day.
Yeah, let me explain something to you here right now so that everybody understands this too. You can object to the dismissing the case without prejudice. You're ready to be able to go to trial on this issue, and you really want to be able to go ahead and move forward with this thing, because at this point, what they did, the reason why they did that is now because there's nothing on the record about your motion to compel. There's nothing on the record about requesting them to be able to deem that those documents admitted in the records. If they're deemed admitted, now you've got a hell of a record. If as long as those requests for admission, production, all that stuff, they're all deemed admitted. Now they can't come back at you no more because that's already on the record now. This is one of the mistakes that we make that I've seen in the past where they'll pull you off in another direction. People think, oh man, that's so great. I'm wonderful. I'm thankful. They dismissed the case. I'm out of here. So what's going to happen?
Right. They
3
come
weeks,
back again.
Yes, 3 weeks to a month. They're going to come back at you, hit you again.
So how does he object to get them to go with prejudice?
What you're
Not
going to
without.
do, you can file it. Either we're going to move this without prejudice, or I want to go to trial on this issue, Your Honor. And I want my documents because they failed to meet with this one here. I want them deemed admitted.
So
If
some
they
sort of
fail
an
to comply with
opposition
that.
or objection.
No problem, man. Ron, we gonna get you. Don't worry.
What's that?
No, I told you don't worry about it. We gonna get him next time.
Well, that's what they want you to think, right? We'll get them next time and you'll get your thinking. Actually, that was a mistake I made, Ronnie. I'll tell you right now. I made that mistake when I won that case. I had it in hindsight. I thought it was great. Yay, I won and they paid me, but they came back after me. So
We live to fight another day. But the bottom line is, I got another trick for him. I'm waiting on him.
See, that's the whole idea. Is Clark? That's Clark speaking on Ronnie's phone right now. And Clark
Oh.
is another person who's very aggressive on this. Doesn't wait, wants to be proactive, and moves forward against this one here. We're going to fine tune him. He's like Lorin in the regards. He doesn't care about this stuff. He doesn't care about their feelings and hurting them, all this stuff. He's there about justice. Okay, just like Lorin is. When Lorin goes into the courtroom, what he does, he sets them up. He corners the justice. And this is what I talk about, people. When you go into this one, you ask questions, and you always ask questions you already know the answer to. So it puts them in a position that it's like putting them in checkmate, and they're going to become upset. When they become upset, then that means that now you're going to state to the record, you're going to ask for recusal. And why? They're going to say, why? Okay, on what grounds? Well, at this point, your demeanor. I'm led to believe that the way that you're acting, that in your emotional state at this time, you're going to make a ruling on your emotional state, on your emotions, not upon the facts and conclusion of law. And as my evidence, I've raised an issue and a statute and a law, and you completely ignored it, and I have it on the record. So therefore, I'm going to ask you to recuse yourself. If you don't want to, then it means that you either have a beneficial interest in this thing to be able to working with the plaintiff, or you have an interest in to hurt and harm me and damage me.
Yep. And Mel has been patient with her hand up. So let me go to you, Mel.
Okay.
Wow, recuse yourself.
Mel? Going once.
Mel?
JD, you're up, buddy.
You said JD?
JD, yeah, you're up.
Oh, right on. Well, first of all, I wanted to just say something about Dennis Block. He's out here in West Hollywood. He's a one of those back of the bus or back of the AOA handbook
Is he an
magazine
attorney?
attorney. Yeah. He just pulls a kind of a an easy. He likes the easy unlawful detainer deals, and if somebody responds, that's when he kind of he's just hoping he's going to get an easy win and just charge $800 and call it a day. But it's I don't know who appeared for him. I think maybe there's a guy named Shahryar or something like that, some Iranian guy that he works with. But the other thing I was going to ask you, I was looking through some of the documents, like the taxes and all the the gifts and the all the investments that the judge has and and that is filed. Is there a certain place that that we can get more documentation or more information and what do we do with that information to expose them, or is that not even the right route to take? You know what I mean?
Maybe a little sensitive with what Lauren's going through. Let's see what happened, how Lorin
But
is, right? I mean, I don't know if anybody wants to follow Lorin.
I mean,
Yeah,
you
you're
don't go down
going,
that
Lauren.
road, but you gotta, you start talking about oath of offices and bonds, and how you're going to conduct this case according to how, the rules of your bond. you can ask a lot of questions. They're going to tell you you're going to need a FOIA request because I asked for the call log. Now, the representative, when you go to the FBI building, you got to sign in. There's a sign-in log. And so I asked for the sign-in log from back in February and March of 2019. And they sent me to this FBI place saying, well, we're gonna label this as a threat. And I said, if it's a threat for asking questions, we don't really have a country, do we?
Yeah.
And so, you can answer that, but the question, the big question is how you're going to apply it. If they give you the information, what are you going to do with it? How are you going to apply it?
That's right.
Is a $64,000 question.
Yep, that's
It's a
what I'm
much
looking for.
more, yeah, it's a much more loaded question. It's a good point. You gotta really, if you don't have the remedy already in mind, the entire master plan at the end, don't bother getting that information because you won't know how to use it until you see the end goal. Mel, you got your
Right,
hand
right.
up.
Wait, I didn't
Can
finish
you,
my question. Oh,
Hang on, JD. Mel, you've been waiting. Go ahead.
can you hear me?
Yeah, we can hear you now.
Oh, yeah. Okay. It's kind of not related to all this, but I just have a question regarding, I had it was an eviction, unlawful detainer, and had an stay pending appeal. And during that period of time, the judge required, I think it was based on I want to say 793, but I don't think that's it. I can't even remember. But the judge required me to pay monies monthly that they were calling for rent. Okay. So over a period of time, these monies accumulated up to $53,000, which have just been sitting in this court fund. So ultimately, through a series of events, my appeal never got heard. Everything was remanded back down to the UD court. And that was in, I think it was August of last year. Here's my question. Those monies have not been touched, even though the judge kind of sort of ordered the plaintiff to take the funds as well as take my home. I think the plaintiff knew at the time and was advised by a judge actually in a bankruptcy hearing that he possibly was in over his head and didn't really know what he had walked into. I'm wondering if that's why they left those funds sitting in the court. So currently, they've submitted a motion for a hearing regarding the release of those funds in August. My question is there any kind of a statute regarding dragging of feet, or the fact that it's been almost a year and those funds have never been touched by them? And they're not entitled, and that's another story. But I'm just curious, just to kind of fast track this process along, does anybody know of any kind of a statute?
86
would-
and 87 of the Civil Code of Procedure would be where I would start. Was it a
Would-
limited civil action or unlimited?
No, it was limited, and
Okay,
we're
86
gonna
and
attack
87.
we're going to attack the fact that it's over that amount, but
Yeah.
but what I'm asking is if I could actually shortcut that and say, wait a second, they've just dragged their feet. They never did anything. And now all of a sudden, after almost a year or 6 months or 3 months, they're wanting those funds. They forfeited those funds because they never took action. Is there any kind of a statute? Because I was looking and I didn't see anything, but someone told me that they believed that there was. And so that's why I'm
Have
asking.
to search for statute of limitations probably regarding
I-
that certain procedure.
And I looked for that, but maybe I wasn't searching it properly, because you would think that there possibly would be, because they were, quote, dragging their feet.
Well, the statute of limitations are in different areas of the code, so you're not going to see it in the same place as that. Be mindful. So
Right.
if that code is whatever 790 or whatever,
Right.
the statute of limitations is in a whole different body. So you have to know where to look.
Right. Well, I'm going to be working with Richard on this one thing, because I mean,
Richard knows everything. He's like, he knows
No,
he
I
knows the
don't.
secrets of the world. He
And
even knows
he
what women
doesn't.
think. He even knows exactly what women think.
he's a know-it-all.
that's
Yeah,
that's why
right.
he's called the love monkey, right? So,
Modi, you're up, buddy.
I was told that no man can read the mind of a woman because the one part, the rib that God used to make a woman, contain that element. But anyway, I was just wanting to put in, congratulations on that one gentleman with the getting dismissal, but it sounds a whole lot like my case, which Richard knows all about. And we try to get exposure back to, viewing the forged note that they produced in court and everything else, and they dismissed her case. But don't, like Richard says, don't rest on your laurels, because they're going to come after you. They come after me within about, I found out statute of limitations was a year. They come at me about 11 months. And Richard can say what he wants about it or what he thinks about it, but I would almost say, Richard, do you think it'd be better just for them to come back immediately with a counterclaim or countersuit against them? What do you think?
No,
They could do that. They could do that, but I think what
No.
they do,
well, you got a limited opportunity right now to do something very special, and I think Richard already nailed exactly what that is. But it's a matter of if he wants to do that or not. It's really up to him.
Yeah. You know what I want to say real quick, like before we move on a little bit, and this for Lorin too. There's a tax suit. Okay, you can
Taxpayer
go
suit.
after for a tax suit. When you go, first of all, you go to the city and you file your claim with the city, the county, and you file the claim with them that you're going to go after these public officials, and the reason being is because before they came to get you, they did briefings. And we don't know how many briefings, but they had briefings on you and your group. And then what they did was the day that they went out there, they had briefings. And then the automobiles and the ammunition, weaponry, and things like that, when they went to your house, that's tax money that they used to be able to go ahead and come after you. See, and all that tax money that they use that tax money in an illegal fashion to come after you. So you can file a tax suit against them. Just a thought.
Yeah.
How do you do
I get
that?
it.
How do you do that?
Lorin?
Me?
Yes.
I've never done a tax suit, Richard.
Yeah, I know, but I'm just saying that's available. They are available. There are tax suits that you can go after them on that issue.
Guys,
Because
I'll be in the law library tomorrow figuring that one out.
Yep, because they would, like I said, they did briefings. They have to get together and sit down and negotiate, talk about do all the briefing about you, your name, your address, what you bet. They've done all this background checks. They used all that tax money to investigate you. And then what they were going to do, and the date that they were going to do it, they had to go to the court to get whatever the warrant that they did. Then what they did is they showed up with all those vehicles and cars and stuff like that, and spent gas, and the insurance money that they used to be able to come out there and do that to you. Then go back, but look up a tax suit.
I'll do that. Well, the other problem that the FBI has, and one of the questions you jog my memory. Now, the FBI can't just show up at your house.
Right.
They have to have a local person with them. They got to have a local sheriff, police, somebody from that municipality, because I've seen FBI guys show up at people's houses and they're all FBI guys, which is totally illegal because they have no jurisdiction here.
Absolutely, it's a federal offense. They're federal, and they still have to have a local law enforcement.
They never get one. They just come, excuse my friends, being Barney badass by themselves. I'm like,
Yeah.
Mhm.
JD.
Yeah, thanks, boss. I was, if you're not getting any relief or remedy from a judge in this administrative court, and you know it, and you can feel it, and you're getting, and they're committing some fraud, and can't really put your finger on it, but they're what he's doing because he's practicing from the bench, and he's, you can tell, everybody can tell, right? At what point do we say, like, okay, let's get to another court, and how do we get to like a federal court at that point? We spoke a little bit about the jurisdiction, but is there a way to just to move that case to another court, and is that a good remedy or good relief or good idea to kind of get out of that, to try to get out of that court, even though you've gone to appeals court you know, you want to go get actually out of that whole kind of state court thing, you know? What do you guys think?
I'm gonna say it depends. I don't have a definitive answer because I've not given it that much thought, but it depends.
Yeah, I'll just tell you real quick, Lauren. I'm sorry. I filed to intervene in a partition case, and then they denied me my intervention. I filed an appeal. The appellate court denied my appeal. They went back down to the lower court, and that's where I'm at now. So I'm like, you know,
Well,
maybe
you have
it's time to
several options to do. One is, depending on how much amount of controversy, you can take it to federal court and sue them. You have to find out if they're just state agencies, or if they're not registered, if they're registered here in state, or if they're in another state. Yeah, it can be done that way. Or you just turn around and you do a countersuit, or you sue them.
Can I chime in?
Yes, go Mel.
I think that just with the little bit of experience that I had this last year with the federal courts, and moving a case into that court, which things were screwed up, but well, I'm really excited about the fact that I believe that we can take these cases, and if you can really show, which I know Richard can masterfully put things together in a great way to show this. But I think that if you go into the federal court and you can show that there really are federal questions of law, like, for example, your due process, you have not been able to get due process from these state judges. If you can show that you really do have a due process issue, and that becomes a question of due process, and that's what they want. If it pertains to a question of federal law, then I think that we can move in there, and you have to, I think, do things according to how they want you to do things, not the state. When you make that transition, you have to come in with standing based on federal law, not state law. So I found that the courts actually were very respectful. My whole case just kind of blew up, and really I take ownership for that, because mentally I just let things fall. But I did see that in the federal court, that the judges, or the judge that I had, when I came in there with a quote federal question of law, and I posed what that question was, that they were willing to listen, and they were willing to give me some time. And so anyways, that's what I have to say about that.
Let me ask Lorin.
Yep.
Have you been in federal and state?
Oh yeah.
Which one do you feel more comfortable in? And do you think that you get more results, or you get favors in, or they listen to you, or neither and both?
You know, federal court is really, they're really funny or sticky about procedures, about protocol, about, I mean, even about spelling, misspelling. You know, the federal court's real funny about that. The lower courts, what normally happens, you get an administrative judge, you get a magistrate, and nothing but an attorney with a robe on to hear the case and do all the legwork, and then he'll make a ruling, and that's why they give you 15 days to appeal any ruling he makes, because it has to go back to a real judge to get a ruling. I find that I've had more success in the lower courts than I've had in the federal court, to be honest with you. I have, but the federal court is they got local rules and local procedures you got to follow. I mean, it's not every court, state court, federal court is different. They got different rules and regs. So there's more to it. There's more moving parts in that federal court than I find in the lower court. That's what I find.
But you can also ask not to have the magistrate. You can specify that.
Right. In those cases, those are just foreclosure cases. They just want him to weed out the stuff to see how far you're going to go, if you got a valid case or not. And, we talked about that briefly earlier. I don't know if you all remember, Chase got fined it was like $30 million because they use a company called, the name now is called Black Knight. And what Black Knight is, you can Google them. What they do, let's say Chase is getting ready to do a foreclosure. They look in your file and see that they don't have all the documentation. Well, they take the whole file, they send it out to Black Knight. They fabricate all the documents they need to make that file complete. Then they send it back to Chase for Chase to do their foreclosure. And they caught them doing it. They caught them doing it, and they gave him like a $30 million fine. But that's chump change. That's nothing.
Yeah, it's nothing. That's like
That's
pennies on
nothing.
the dollar.
Yeah, most of us would get all fired up about 30 million. They're like, oh, that's nothing. We made over 500 million doing it. So, yeah, that's part of doing business.
Yep. They probably made a lot more than that, robbing and raping the people.
Well, yeah, I mean, if you read a book, what's it called, J.P. Madoff, it tells you, you read that book, and it was written by an attorney who used to work at Chase, who got passed over, and so she wrote a book about all the internal workings of J.P. Morgan Chase and how they hired a guy that, this is going to sound weird when I say this, the guy had a PhD in stealing, and they hired the guy and gave him his own parking place because he knew how to steal better than all of them.
I know that guy.
Yeah. You see, well, that's the thing, is that we need to understand, we all fully understand this, that, that the entire stuff is not done really by the banks themselves. It's really done by the trustee companies, these law firms, Wall Street, and the title companies that work in unison. And they utilize these banks. They're not going to say anything, but they use those banks as a reference, and the rest of the documents are falsely created by notaries in different states with false signatures and notaries that either don't exist or do exist, but were just created just for that moment to sign those documents. Scanned in thumbprints, scanned in fingerprints, scanned in signatures, scanned in notary stamps. All this stuff is constantly going on, and you have to do your due diligence to be able to get to where to bring it to the court. But what I say, before you bring it there, once you've done all that legwork, you've got to, since you're not an expert, you have to have an expert when you walk into the courtroom. You've got to have an expert to be able to work with you and go there. And then you really got to stand your ground. And there was something else. Next friend, talk about that, Lorin.
Yeah, we have a document we use that gives you all the case law that you put in to do the next friend. I have a young lady that has a house, and she really doesn't know anything about foreclosures. And her mortgage is void on its face. It's like they said, void ab initio, because void fraud vitiate the contract. She had a guy that stole the appraisal report, raised the price of the house through the appraisal report that she had appraisal program that he had stolen. And she bought the house, and the house went into foreclosure, and we're going back and forth. Then they find that this guy's done this numerous times to the point where he went to federal prison for it. And so, but they keep selling her mortgage over and over again, and we get these new people coming in saying that they're going to foreclose and take the house. It's like, you guys are trafficking in fraudulent securities, and we're going to go down this road. But she doesn't understand that. So we just put in the next friend document, which, Richard, I'll send to you. I got to write myself a note. I'm old, Richard, next friend. I'll send you my next friend document that we use to speak on behalf of someone else.
Yeah.
It's useful. I mean, even if you're seasoned like me and somebody, Richard, sometimes if you got somebody else, that thinks on your level, that's quick on their feet, that are that's paying attention. I mean, if we go to court and I'm involved in the case, I hear some things, and somebody else is going to hear something totally different, based on where your head's at. It would be helpful if that person could pull your coattails and say, hey, did you hear him say this, or did you hear him say that? That would be great. And that's what we use it for.
Absolutely.
And have used it. We've used it in state court, and we use it in federal court, and they've allowed it.
And the thing is with that is that, as a next friend, it's specific on how you approach it. Do you submit the document showing that you have firsthand personal knowledge or knowledge in the area and can represent information that would help the court make a better determination on that issue?
Yeah, you go in as a friend of the court, amicus curiae, friend of the court, is where you want to go. You don't want to be considered, under Trading with the Enemy Act. You don't want to be an enemy combatant, because that's what they label all of us as enemy combatants. That's why the judge and everybody talks us like we're crazy 90% of the time. So you have to dispel some of those rumors. And what I try to do is get all that in writing before we get in there.
Absolutely.
Get all that on the record before you get in there. You know, I'm over 18. I'm competent to handle my own affairs. You know, you've got to, I'm above the age of majority. You've got to put all that on the record, you know, accept the judge's oath of office, accept the Constitution, put all of that stuff on the record.
Mal, you have a question? Or a statement? Mel? Mel? We can't hear you. If not.
Yeah, this is Mel.
Oh,
All right.
yeah,
Yeah.
Can you hear me? Can you hear
Oh, there
me?
you go.
Yeah.
This is just another idea that I had. This is something that I came up with, and I haven't researched it. But another issue that I'm dealing with is the fact that this judge illegally expunged my lis pendens, which I'm hopefully going to go back in and do something about that after, you know, a decade or whatever. Joking, but seems like it. But anyways, I was doing some research on constructive notice because, as you all probably know, when you have constructive notice, basically at the onset, you have a buyer, meaning who's ever coming in at an auction cannot be a bona fide purchaser, because if they get constructive notice, then anything that happens is basically contingent upon the outcome of what that constructive notice or that lis pendens is referring to. So I was doing some research because I don't have that lis pendens in place right now. And what I saw was that any of us, I think, oops, can you hear me?
My case.
Yeah. Block your voice, block it, mute it.
They keep
Cynthia.
talking about how wealthy this asshole
Cynthia.
is.
Put yourself on mute.
Sorry.
Okay, go ahead. Yeah.
So anyways, this was just a thought that I had. It's just another deterrent in a way, but it may be able to help, is that what I determined, and I haven't researched it, you know, to an ultimate conclusion for myself, is that you can have constructive notice if you just run an ad. And I don't know if it has, yeah. And so
The
if we,
constructive notice is considered when you record a document, that's constructive notice. But
right,
see,
but what I'm saying is my lis pendens, for example, that was recorded, and the recorder's office can be very difficult about bringing documents in to record, at least in San Diego. So you can bypass that and just go to a local newspaper and run an ad. That is in itself considered constructive notice and holds supposedly the same weight. Once you do that, you've now changed the game a little bit, because that entity, that who's ever coming in or whoever wants to buy your property, if they take it to auction, becomes a non-bona fide purchaser, period, end of story, because there's constructive notice.
absolutely. There's also case law, and I think you might have it, that talks about a competing title claim, where if you already have a competing title claim, like right now, I know Ramon didn't hear this on this case. Basically,
Right.
what happens is when the property is going to go to sale, if you filed your claim, you filed your suit, and then you got a lis pendens, what you do is you serve the, like, auction.com or the trustee company, give them notice that you've got a suit going. That's notice to them. You've given them notice on that right now. So now they have to give notice to whoever's going to buy or go to buy the property that this is in litigation. And now they don't become a bona fide purchaser of value.
But they don't always do that, because that's what happened with mine. I mean, all the title companies knew about it, and
Yeah,
know,
but
when
you, as long as you got evidence that they served them, and you served them and give it to them, then it's on them. It's on those
right.
people.
But what I'm saying is to circumvent the whole uncomfortable process anyways, because when my property was sold, the auction was rigged, number one. Number two, everybody from Barrett Daffin on up to the title company that gave them the TSG that was completely false, knew that there was a competing title claim, knew that there was a theft, and knew that the criminal was in prison, or that he was being sentenced. They knew all of this, but some of these companies are so bold. And so what happens is when and if they can expunge, which they did unlawfully, which, you know, shame on me, I haven't gone back in yet. It leaves you without any recourse for a recording. So like right now, what I'm looking at is going in within an intent, even though people may say this isn't for the right purpose. I saw a document with regards to an intent to preserve interest. And I know the recorder's office will record that because they've got my home in escrow right now, which honestly, if they sell it, so be it. I don't really care because it's just going to add to the damages that I have because
Yeah, but
there's,
let me show you something right now. I got Lauren on here. I'm gonna ask Lauren a question. Listen to this right now.
okay.
Lauren,
Yep, I'm here.
okay, you're in court. I got you in court, and then I'm the judge. Okay, I'm the judge in the courtroom, and you raise an issue. Let's say you got an expert documentation examiner. You raise the case law and the statute showing that that I should be ruling in your favor, and I just completely ignore it. I just say, well, no, I'm going to ignore that. No, overruled. What are you going to do?
But if he says I'm going to deny it,
Yeah,
then I'm going to
deny
ask for
it.
the finding. Yeah, I'm going to ask for the findings, facts, and conclusions of law that he used to overrule it. I mean, to deny the motion.
Okay.
And then if he says, and here's their main thing that we all run into is they just ignore the whole conversation like it doesn't exist.
Absolutely. Yes.
Right. So they go past that. So then I say, well, I guess you agree by your acquiescence, right, Judge? Because I'm sort of a jerk now. I don't have a problem with telling. So I guess you agree by your acquiescence. That means you agree, correct, Judge?
Yeah. See, and then what do they do after you say that?
Oh, now he's got to engage. He can't let you get away with that. He's got to. Well, the judge in my case was saying, well, we need to, we need to talk about this. And in my case, he cleared the courtroom to try to answer a question because he didn't want the jurors to hear what I had to say, basically, not what he had to say, but what I had to say. And we go round and round and round and round. And finally, he said, well, we're going to have to, what did he tell me? Something about not suspending it. Basically putting it on hold. I don't remember the term he used. And I got a pretty good memory. Basically, we're going to put it on hold and get back to it, is what he said. But that was a way to get off of it. Not so at the end of the day, I said, Judge, we got something on hold. We still have an open issue that we need to get a resolution to.
I need a judicial determination on that issue.
Exactly. So then he said, then they want to play like they forgot. Oh yeah. No. I got it written down on my notepad. I know exactly what I need for you to do. And so finally he came back and said something nebulous that didn't really matter at that point because I wasn't gonna move off of it.
Yeah.
And I was just gonna stay with it. We weren't gonna go anywhere. I mean, I don't care if I got to stand there for 2 days. I wasn't gonna get off of it. I'm sorry. I get kind of a bullheaded, stubborn, whatever you want to call it. I just get on the topic I want to be on, and I stay on that. I don't care what they talk about or what he threatens. Any of that.
Yeah, absolutely. See, this is one of the reasons why most people that go into these courtrooms, they talk about it. Oh, they ran over this and they did this and they did that and they just let it go. As long as you got a court reporter there, there's questions that you ask. And when the judge overrules or denies certain things like that, you want the facts and conclusions of law. I just provided for the courtroom a case law and the statute that are controlling in this courtroom. So therefore, and plaintiff, who's not here, or the attorney of record who cannot testify before the courtroom, has not provided any evidence sufficient for you to be able to make a determination in their favor. So therefore, I'm asking you a question. That's what you want to do. Is you want to ask them a question, and I said I need that for the record. They're not going to. They're going to want to. They're going to get mad. They're going to get upset. And you say, well, I said I've just asked the question. I said therefore, I said you don't want to answer, and I'm going to ask you to recuse yourself. Okay, I'm going to ask you to recuse you because I need a judicial officer who's going to make a determination on the facts and conclusions of law that I presented before the courtroom. If you don't want to do that, see, what you want to do is you want to build your case. You want to have your statutes, your codes, whatever you're going to use in there, and you're going to have your court report, yours with your court transcript. Now you can go after and you can take that to the presiding judge and tell him, look, you got to just have to completely ignoring the statutes and codes that govern this courtroom. And then you can write to the governor, to the Supreme Court, county council, and make them all aware of this person, this particular judge is completely ignoring these things. Okay. And then if that, and you can, even to the judicial council, you can write to them, everybody, make sure everybody knows about that. So it's like you're going to spank them and openly. And then what you do is, if he doesn't want to do it, you're going to ask him to recuse himself. And if he doesn't want to do that, then what you're going to have to do is you're going to take everything into federal court now. But with all your facts and evidence to show that he continues to ignore your due process right, your equal protection, equal access, and all the statutes and case law that you presented before the courtroom. And on the record, there's nothing from the plaintiff that was provided, objected, or challenged, or disputed at that time when you were arguing this issue. So these are the things that we really have to do. We got to take it to another level on all these issues. We can't just let them do whatever they want to do inside the courtroom. Once you understand, it's like this. When you first went to play chess, you were having fun. The guy, they were beating you all the time. But once you begin to understand and learn it, you might see that they were doing moves that they didn't have a right to do. Now you learn the game. Now, hey, they're not supposed to do that. See, and this is what I always tell everybody. You're in the fight, Lorin, you're in the ring fighting Muhammad Ali, and you're beating him up and stuff like that. All of a sudden, you get hit from behind. You turn around, it's the referee. Can he do that? No. So once you understand the rules of engagement when you go into these courtrooms, you know how to play that game. You know how to corner and control everybody. An attorney can't testify. The DA can't testify. The judge can't ask discovery questions. The judge can't practice law from the bench. You know, the judge can't assist you or the other counsel on either side. They can't add case law to support either side, but they do it all the time because everybody just, well, I guess that's the way that they're supposed to do things. But
Well, Richard, we find that they've done wrong so long, they just think it's right. And if they've not been challenged or you haven't gone, you know, the judges in Ohio don't think, you know, they just think they can just do whatever they want when they can't. So you just once you crack their head once or twice, they all get the message. That's not going to be tolerated. And this guy's not going to go for it. We're going to have to find a different way to deal with this thing.
Absolutely.
And you have to make them respect you in the courtroom. And 90% of this, ladies and gentlemen, 90% of this is your posture. It has nothing to do with what you're saying. It has more to do with how you stand before them. Because I stand in the courtroom like I own the whole courtroom and everything else.
And you do.
And I'm not taking no prisoners. I'm not trying to bring them back alive. I'm taking over the entire courtroom.
Absolutely.
If he doesn't like it, let him go somewhere else. Judge, is a federal courtroom, belongs to the people, not you.
Absolutely. JD.
You gotta have that posture. The posture is everything in there.
Absolutely. JD.
Oh, yes. Thank you guys for that information. I was I wanted to know, have you ever experienced, Lorin, a court receiver or referee? Because that's what I'm dealing with now. I just wanted to know if you ever had experienced somebody from outside, you know, a private for-profit person coming inside the court and making rulings and stuff.
And you must be referring to like a mitigator. I've not experienced most of them, honestly. Most of them don't want to be in a courtroom like that with me anyway. I mean, they'll start out as if they're in charge and they got all the answers. And when I challenge their authority and how you're arriving at that decision, and I come at you with all the questions, I'm going to come at you. Most of them are like, I don't want to tangle this guy in here. You got too many questions. Yeah, I'm going to ask some questions. Where'd you come from? Who gave you authority? Who do you know? What is this about? I'm going to ask some hardcore questions that these people don't want to answer. I ask hardcore questions judges don't want to answer.
Yeah.
I don't care. I simply don't care in the courtroom. I just don't care. Because they're lying, the prosecutor's lying, they violate the Constitution, bring you in there on that nonsense. It's not an article, it's not a Article 3 court, and it's just all wrong. They make false statements all the time. I look at this kamikaze indictment they put together, and the prosecutor's lying through her teeth, and they allow them to do that, and then they're speaking in the court, and you object them to it. You give them the case, Trinity versus Pagliaro, an attorney can't submit evidence, won't be a witness. They're like, well, that doesn't apply here. Whoa, stop, judge.
No jury, no trial by jury.
I at this point in my life, I would never do a trial by jury again in life. I'll tell you that.
Really?
Ever.
You'd rather do bench? You'd rather do bench?
Oh, bench every time.
Yeah.
Really? Could you guys
bench
explain
every
a little
time,
bit?
guys?
Tell us a little more.
Okay, so if you go to trial with 12 people you don't know, and they know nothing about the law, and the prosecutor doesn't give them, let me phrase it, the prosecutor withholds information. Like in my case, the prosecution never told the jury what the elements of the crime were and what they had to prove. They never once said you got to have money exchange hand, this, that, and there were 5 elements in the wire fraud, and of the 5, they had 2.
Well, couldn't you bring that up?
Yeah, but after she's drilled out, after she's gone at them, I don't know if you've ever been in a federal lawsuit. You ought to,
No, not yet.
I tell everybody this, even if you haven't been in one, go sit in the courtroom and watch how the prosecutors do the same thing over and over again. All they do is find one topic, and they just hammer this one topic until these people believe it. They just hammer the one topic. Like they kept saying bankruptcy fraud about somebody not signing. There's three questions in the back saying, did anybody help you fill this out? Did anybody help you fill this out? But what the rule is, if you don't fill it out, you don't sign it. The rule is, if you don't fill that document out, then you don't have to sign it. I never filled out a document, not once, and nobody ever said I filled out the document because I didn't. But they failed to bring that out. So now you got to try to go in there and convince these people that, hey, I didn't do that.
That if you don't fit, don't quit. If you don't fit, you got to quit.
Well, you say that, but then you got these 60, 70-year-old people in here that they're just doing their civic duty and believes that you're guilty just because they indicted you.
Yep.
Guys, we're all in this thing together. Some of your own family members, my brothers and sisters, my sister got a PhD. My sister got a PhD. You know what our thought process was when I going through this? Oh, you must have done something, otherwise they wouldn't be coming after you.
Yep. Right? My brother's a cop. He's like, yeah, you got to follow the rules.
Yeah. My brother's a CEO of a major corporation. He's like, hey man, you must have done something, otherwise they wouldn't be after you. Hey man, I didn't do anything.
Lorin, how would it have been different with a bench trial?
Well, the judge, as a matter of fact, and the judge, their rules and regs, like just as I just stated, they're elements of the crime or the statute that they're using that they have to prove on the record, and they never did. As a matter of fact, in my case, the judge told me, he said, Lorin, you need to file a Rule 29 because they've not made their case. The judge tells me this. So I'm saying to myself, had I had the judge, he wouldn't have let it gone that far.
On the record, I read your motion for exoneration, or on that, wasn't it? And he was it ruled untimely? Was that his ruling?
Yeah, that was his ruling. It was done untimely.
Yeah.
That was it.
Yeah,
that was it. But the issue for me was, you haven't put a ruling on the record for us to move on. So we're playing a game here.
So he's saying it was untimely, but there hasn't been a ruling. So he's going off. So did he say he's going off of the notice of entry of judgment?
When I asked for findings, facts, and conclusions in law, I'm still waiting on the answer.
We have something in California. It's actually called a statement of the case. So I'm wondering if there's is that what you're waiting on?
Basically.
Is that it, Richard? Statement of the case? No. NOST, notice of statement of decision. Sorry, statement of decision. Yeah. Statement of decision. It's the statutory, they statutized facts and conclusions of law. They use, in the common law, it's facts and conclusions of law. And then in the statutory, it's statement of the statement of decision in California.
Okay. I'll look it up. Statement of decision. I'll find it.
Yeah.
I'll be in there tomorrow. I'll be at my job tomorrow.
Yeah, they might have that in the federal rules. I don't know.
I'll get it. Yeah, but he doesn't, the judge is in a little in a pickle. He got himself in a little bind there because he should have, on 2 occasions, he should have dismissed his case. And both times he dropped the ball. Because I had him on the 71 days speedy trial, and I hit him with that twice. And he kept saying the public interest.
Yeah, Lorin, I really hope that you'll take what I said. I think Modi mentioned it earlier about another guy about Modi said something about, it was a word, I didn't know how he pronounced it, something, and I couldn't find out what that meant.
Elocution? Elocution.
Yeah, elocution. So, but if you look at the statute, it's a penal code. It's actually not a statute. It would be considered like kind of like the statutes at large in federal court.
Mhm.
But it's a penal code, and I posted the raw penal code. It's not a
I got it.
statutized version, but you look at that. It says consent is required at sentencing, mandatory.
I got it.
Now, I know if anybody's gonna do it, you ever get to that point, then boom.
Yeah,
you
I'm
know?
at it. No, yeah, I'm all over it. But my thing
It
was to
can-
file a stay and
Yeah.
stop the
Oh,
sentence
yeah.
hearing and then do the show
For sure.
cause and then just prosecute the prosecutor and the show cause. That's the plan.
And are your hearings public?
Yes. Yes.
All right, I subscribe to your case on Pacer, so I'll keep an eye on it. And once they
Yeah.
have another hearing, I'll let everybody know. It will come down there and watch you in action.
Yeah, well, yeah, I think you might be able, and they might be able to see it on Zoom. You don't want to come to Ohio.
Oh, we were talking about coming in person.
Yeah.
Oh, well, that's good too.
He's gonna put his cheerleading outfit on.
Yeah, it's all good. I have no problem with that. I have no problem with it. But enjoy
Do they
it.
let pets and do they let pets and rodents in the courtroom and cockroaches,
Yeah, they got attorneys and judges.
monkeys and the whole thing? Oh yeah.
We already got them in there. They're called attorneys.
Oh, okay, they're in there. Good.
Well, the thing is that it's all about how you go into the court. Even when we always talked about this, all legal actions that you're dealing with the roads lead to the courtroom. And that's where you have to be prepared, to be able to go ahead and present this. And it's a chess game. It's a chess game that they've been playing for so long that you really have to understand that. You really got to read and look at things, look at case law, ask questions, role play in your head, look at the things that they're bringing up against you. And then what you do is learn how to act quickly on what they're saying. And sometimes when because when you're new at this, a lot of times you get in there and you become confused. You can ask the court, give me a minute. I'm going to review my paperwork and try and make a determination on that issue or make a statement. You can ask them like that. I've done that before in the past. And I've made a lot of mistakes in the beginning too, just like everybody else has.
Mhm.
But then once you get beat up once or twice, you say, that's it, I'm done. I want to learn this game. And that's what we're here for today. And I thank Lorin so much for his wisdom and his knowledge and what he's doing right now. He's like a trendsetter right out here, and he's not afraid of what they're doing. He's going after them wholeheartedly, and then he's researching just like we all do. And we need support from each other to help each other,
That's right. I agree 100%.
Yeah.
It would help if you had a study group, if you had some people, like-minded people that you could, pick up the phone and just talk or just run things by each other. I got a couple guys that I use to do that. One guy out of Detroit and one guy out of Chicago. We try to get together quarterly, and we actually go to Chicago and spend 3 or 4 days going through stuff.
Absolutely.
Just, hey, here's what I got. What do you got? And we do the role playing. I spend a lot of time doing role playing.
Absolutely.
You have to think about how they're going to respond to questions that you ask. You got to think about what their defense is going to be. You got to think about how you're going to overcome it before it even comes up. I try to think 2 or 3 steps ahead.
It's the same as chess. You get in and play
Yeah.
chess, you don't think one move ahead. You see these guys think like 10, 20 moves ahead, based upon what you do. They look at what the other person, they're calculating what the other person's going to do and watch him. When he does that, they already know it. Then they move in their position.
Right.
So it's the same thing here. You have to really study this game. And it's unfortunate for us. I'm really upset because they say it's an equal playing field. You find that to be true, Lorin?
Oh, absolutely not. Absolutely. If let me tell you what, the struggle that I have, and it really gets me fired up, is the feds couldn't win a case unless they have attorneys helping them, unless your attorney helps them. The feds can't win a case without somebody else's help. I'm telling you all don't have to believe me if you want. The feds cannot win a case unless the other side, unless your attorney helps them. They can't win a case. They don't have the wherewithal. They don't have the manpower. You know, that we got cases where they go beyond the 71 days. We call that slam dunk. You try to file a motion to dismiss for speedy trial. Judge comes up with 5 or 10 excuses about it's not in the public's interest. What is the public's interest? You know?
Yeah.
But if your attorney doesn't help them, the feds wouldn't win the case. I'm convinced, 100% convinced of that.
So after how many days did you bring that motion, Lorin? The
Oh,
speedy trial motion.
Man, I brought that thing after 9 months.
9 months?
Yeah. Then after that, 18 months again. I mean, they had this thing on hold for 3.5 years. While they got you on this nonsensical pretrial stuff.
Did you waive time?
No, I don't waive time. Ever.
How's that possible?
Well, you tell me.
That's completely backwards. I'm like, what?
Yeah.
That's what needs to be exposed though. You know, because
That's not even reasonable.
Not even conceivable. We put it on the record. I put it on the record twice myself. And every time he kept saying,
what does the
speedy
Supreme
trial.
Court say about that?
They throw it back on judge's discretion, which is a joke. What does that mean? What does a judge see? Here's a question I asked when they said judge's discretion, and ladies and gentlemen, this is how I think. When they said judge's discretion, I'm scratching my head saying, does his discretion?
Yeah, whatever he wants it to be.
Well, that's fine. That can be what he wants, but does his discretion supersede the Constitution?
right. Right. You're absolutely 100% true. Correct on that.
In those courts, though, there's no Constitution. I don't feel. I feel like they don't care about the Constitution.
Okay, so then they can turn that on and off whenever they want.
Apparently, it's like we're their employees or something. Like we work for them.
Then we need to accept the Constitution on the record and accept their oath of office on the record. Now it does play a part in the court, and he can't deny it.
And how's that done?
Hold on, JD.
Okay. Sorry
Yeah,
to raise
raise
my
your
hand.
hand.
I just want to know how it's done. Sorry to raise my hand.
And Lorin, yeah, let me just dovetail on what he's asking there. Let's say that it was done. Let's say someone did accept the oath of office and put that on the record, like got a certified copy of it, got a certified copy of the bond. Let's just say that happened and put it on the record and accepted that. Then what?
Okay, now
And let's say it goes on. Yeah.
So then the second question I'm going to ask the judge: are you going to conduct this case in accordance with your oath of office and the Constitution? I'm going to ask the question on the record. Is this how we're going to conduct this case?
He said, I don't have to answer that. I can't give you legal advice.
Is that legal advice? I'm asking the question I'm asking, Judge. Does the Constitution apply in your courtroom or not? That's a yes or no question.
I'm not here to answer that.
Judge, you're not here to answer. You're here to make a unbiased ruling, correct?
Well, yeah, I can't give you legal advice.
Judge, are you here
sir.
to make unbiased ruling?
If you want legal advice, you got to go outside and get some legal advice. Can't help you with that.
Judge, now I'm an idiot. Judge, Judge, are you here to make unbiased opinion? And does the Constitution apply in your courtroom? That's not it's a yes or no question.
Crickets. Crickets.
Yeah. Oh, so you agree by your acquiescence. Judge, do I take your acquiescence as your agreement?
Crick, this is when they shut the camera off and the judges, hey, where'd he go?
Yeah.
Judge.
Judge, by your acquiescence, do you agree?
Move on, sir. This is what it says. Move on.
Well, Judge, I'm just a little bit confused why we're moving on. That issue is still open and needs to be addressed.
Well, any further questions, Mr. Prosecutor, for the defendant here?
Yeah, shut his mic off.
Well, and literally it happens like that. They just go right to the, well, Mr. Prosecutor, what do you have to say? You know, they try to get off of what you're talking about.
Yeah.
So I just let them go ahead and talk to the prosecutor, ask them all the questions they want to ask. And as soon as they're done, I go back to my question. I don't care if I got to ask this question 100 times. Judge, does this apply in your courtroom or not? I didn't get an answer. Can we have an answer for the record? Let the record reflect the judge is saying the Constitution does not apply in this courtroom. Let the record reflect that.
And did
How
you
gotta
make that,
stand.
did you make that record?
Yeah,
And what did he say after that?
crickets. He went to another topic. He changed and went in a completely different direction. He wasn't
he
going to
let-
address it on the record.
He let the record reflect that.
Yeah,
Wow.
they've been doing wrong so long. I'm telling you, they don't think they think it's right until we absolutely crack his head. He's going to keep going down this road.
Dude, I got overruled over and over and over, and he didn't care. Object to the attorney's. I overruled. Okay, the whole time.
Yeah,
They don't think we have any recourse. That's the thing. They don't think we have any, any ability to go somewhere else.
Mhm.
There's no consequence.
there's no consequences to them. Trading with the Enemy Act doesn't apply here. What are we doing? Are we treating me as enemy combatant? What are we doing, Judge? Thought I was amicus curiae. I thought I was a friend of the court.
So that's
You work for me. You work for me.
At that point, then what you want to do is when the judge don't want to answer, I'm going to have to ask you recuse yourself.
Yeah.
You're going to have to ask him to recuse himself because at this point you're going to harm me, you're going to hurt me, and you're going to damage me. You've already prejudiced me by not answering a simple question. And you as a judicial officer is going to breach the public's trust because we put you in trust to be able to make sure that you had the ability and the knowledge to be able to make a legal determination based upon facts and conclusions of law. So I would hit him up like that. I said, I'm going to have to ask you to recuse yourself and stay this action. Yeah.
Did you do that, Lorin?
I did not do that. I wasn't that far into it. I was like, I ain't getting no answers.
Yeah.
I ain't getting no answers. I want some answers.
Yeah. Absolutely. You want them because they have to make a determination. There has to be, because you cannot see the days of just standing there and letting them be stupid are over. We need to be able to get a legal response or a judicial determination based upon what you have before the courtroom. And you have to understand that. You have to understand either the case law or the question that you ask, you already know the answer to, and he's not unwilling to answer that. And he has the right, according to what Lorin has asked him. Are you going to, abide by the Constitution or the Constitution in this courtroom, controlling this courtroom? So,
Richard, what about that? What happened that time that you came in there and the judge was yelling and screaming at you? What happened in that story when he was, screaming up the top of his lungs? What did you say?
I told my son, you're not my father. I'm not your son. I said, you have no reason to talk to the people like that, So then he changed his demeanor, and then at that point he just, he just said I was under investigation due to the fact that he believed by the attorney who stepped in there that I was filing false doctrine, practicing law from the bench. I said, well, I understand the law. I understand the statutory scheme, the summary nature of this courtroom. So that's why when I did that, then it made everything change, but they still wanted to do me in.
Was that the time you asked you had asked if he would mind washing your car? Was that the judge that was washing your car, or was that someone
What
else?
you do is you ask them about, are you a public servant? Oh boy, do they come unglued when you ask them that. They get really red-faced, because they just want to beat up somebody. Because when you ask a judge, are they a public servant? When you walk into the courtroom, he's above everybody, sitting up there, and everybody believes, oh, this is God there. And when you ask them, are you a public servant? Now you place them below everybody in that courtroom. And they don't like that. But they have to answer, even though that courtroom is a private corporation, it's a private entity. So that's one of the things that's why they don't want to answer certain things, because here in California, there's two constitutions. Okay. Do you know which two those are?
Yeah, well, we've got the 1849, that's the de jure constitution.
Right.
And then the 1869?
79?
79, yeah.
Yeah. So you got two constitution. And which one has the other one been ratified? And then you stop and think, okay, you have, those are the constitution were put there. Okay, then in the state of California, a corporation, or is it an actual government state?
Corporation.
Which constitution are you referring to, I guess? Is it the state of California? Are you talking about the California Republic or the state of California?
Yeah, so you got the California Republic, which is actually the government, but then when you got the state of California, which is a private corporation, so it has its own constitution per se. It has its own rules, policies, and codes.
That would be admiralty law.
If it's a private corporation, yeah, it could fall underneath that, under admiralty law, contract law.
They blended law and equity together, so it wouldn't necessarily be admiralty law. That's for shipping and marines. But they blended law and equity together, so it's confusing, and they think that.
You go to the courtroom and you'll see a flag with the fringes. That's admiralty law.
Yeah, you know, they talk about that, you know, and you walk in and they won't pay attention to all that stuff. And that's why I say that you have to stay away from certain things until you have everything down 100%, because you'll waste your time. You'll waste your time with these people, you know, and they're gonna look at you and they say, oh, here it comes. One of those patriots are gonna waste my time with time. Let's just get them and put them away.
The gold
One of those sovereign
flag.
citizens.
Yeah, so what Lorin's doing is he's hitting them correctly. He's stopping them. If he wasn't, they would already had him put in jail.
Yeah.
Okay. He would already been.
You raised the gold fringe flag argument, Lorin?
No, I did not. No, I did not.
No, he wouldn't. That wouldn't be a good move.
No, I did not.
He knows it. You see, we all know it. We know the truth, but we don't need to tell it to them. You know, like Richard says. You know, just keep it and do use strategy and kind of get them out. You know, we know the deal.
Yeah.
You know, you're going to ask a question. You know, the thing that they like to do in court is they try to mislabel you something. I heard someone earlier say they want to name you a sovereign citizen. What's a sovereign citizen? What is that?
Oxymoron.
Yeah, it's an oxymoron. When they start labeling you that, what you mislabeling, you call what am I? Am I some fictional person? Or am I a live human being? What am I?
Oh, you're for sure not a person, remember.
So
Well,
you really seem like you've mastered this question thing, Laura. I gotta give it to you. You know, I haven't. Has Lorin been making claims? You got me kind of bamboozled right now. I haven't heard too many claims from you, buddy.
I'm not gonna make any claims. I'm gonna ask questions because, you know, I don't know if you guys remember Rich, the guy from Texas, old guy that does taxes. He's a good old boy, 70 years old, really nice guy. Went down and spent 2 days with him. He does taxes. Kerry Zolman, old guy.
Yeah.
He's the one that got me asking questions. Because Kerry will have you. Kerry and 19 other guys got indicted on some tax deal, and 18 of them went to jail, and Kerry didn't because Kerry kept asking questions. The guy said, "Did you do X, Y, and Z? Yes or no?" Kerry answered yes and no.
Yes and no?
The guy said, here's what the attorney asked him. He said,
hilarious.
Did you, I forget, do something with your tax returns? Yes or no? And so Kerry said, yes and no. and this guy's 70-something years old, and I wouldn't spend 2 days with him. And all he did was had me asking questions. He had me in and out of that doggone tax code so many times I was sick of it. But the point he made was, if you ask questions, you don't have to defend it. If you make a statement, you're going to have to defend it. That opens the door for them to come at you.
See, and the thing is that what you're doing though, sometimes when they ask you a question like that, you're asking me to make a legal determination based upon information that I have no knowledge of. You know, I don't understand legalese, and I'm not an attorney.
You know, it almost goes back to that syntaxing thing where we all assume we know what they're talking about in court when they make these statements. Right. We just assume we know what they're talking about when you don't. For instance, here's one that my mother-in-law did to me. When the judge goes to court, he's wearing a mourning robe. He's wearing a black mourning robe. The question becomes, is he mourning death, or is that an AM? Which one is it?
Well, I mean, they say that, we're all, the person is dead. It's not, they're all paper and they're all
JD,
person.
raise your
I
hand,
thought-
buddy.
I thought he's asking a question. My
Please.
bad. Why don't you cut
Let's
it?
go.
Sorry, my
Let's
bad.
go.
You go ahead and cut
Yeah,
it.
but my point is, we assume that we know what they're talking about, and we don't. So to get some clarification, the only way I can get clarification is ask questions.
Absolutely.
Because I don't want to answer something incorrectly and walk myself into an implied contract, just like you did with the arraignment when you asked the judge, well, judge, you're going to be my attorney throughout the trial. That's an implied contract that he can't perform on. So he has a heart attack. You want the court to go up for grabs in an arraignment? Tell him, not only do you not plead guilty, just say I plead equity. Watch what happens.
Was that your plea?
Yeah, watch what happens.
What happened?
Oh, they get pissed. Oh, because they can't monetize equity. They can monetize not guilty.
So did you plead equity?
Yeah, I pleaded equity and I played the equity game. I never gave him anything, nothing, no controversy. There's no controversy for the judge to rule on.
Stay in honor.
How did they monetize your case if you pled equity?
Well, there was 11 other people in the case. There were 11 of us.
And it was the people of the state of Ohio against you?
The United States of America.
And
And when they start asking for taxes and fees, they descend from a government into a corporation. That's in the Clearfield Trust. If you read the Clearfield Trust documents, when they start asking for fees, which that's all they're asking for, they descend from a government into a corporation.
Yep.
So here again, we're back to asking questions. What are you asking me?
I'd asked him, I said, Your Honor, could you ask me a question? Am I a United States of America individual, or not individual, but one of the people of the United States of America?
Am I a public citizen? Am I a private citizen? Am I a private citizen?
And because that'd be a conflict of interest.
There you go.
I'm one of the people.
Well, he's a lawyer.
A liar. I mean, lawyer. I'm sorry.
Liar.
Yeah.
Well, see,
He's a
it's
lawyer
like
with a
this.
robe on.
Yeah, it's like I always say, what, it's always asking a question because, when you're inside there, whether it be the DA or whether it be somebody else, you can always object to them per code. Object to them testifying before the court because they don't have any firsthand personal knowledge. When you object to them testifying or having any firsthand personal knowledge before the courtroom, the judge will say overruled. Then that's when you ask a question. Is the court stating for the record that it's going to allow hearsay testimony from this individual who's failed to swear in and has no firsthand personal knowledge to make your determination in this courtroom here today?
It's just argument. It's not evidence. It's just argument.
What's that?
It's just argument. It's not evidence. It's just argument.
Was the court testifying in behalf of the plaintiff?
No, the lawyers representing the plaintiff.
What's that?
The attorneys are representing his client.
Oh, so you testify on behalf of the plaintiff. So you ought to know that he does represent who he's representing.
Okay, he's representing the client.
Objection. Are you testifying on behalf of the plaintiff? But I'm going to hold my objection because you stated that. So I'd like to ask him some questions now, since you say he does represent him.
That's good.
Oh yeah.
That's good. That's good. Yeah. You got to be on your feet, man. You got to be on your feet. That's very good.
But the thing is now he's not going to say no. Direct all your
No,
questions.
direct all your questions to the court, sir. Go ahead.
Yep.
That's what he's going to say. As soon as he says that, when you say that, he's going to direct your question. And now there's two things that you can do. You can go along with that. Say, okay, well, Your Honor, I'd like to ask him, is he the special appearance attorney to the attorney of record? Or you can go this route, cut to the chase. I said, Your Honor, that raises another strong objection. Are you stating for the record that you have firsthand personal knowledge confirm answer all of these questions? Because if you say you do, then I'm going to have to ask you to recuse yourself because of conflict of interest.
Oh, awesome.
But the thing is that, it all depends on how far and where you want to go and where you want to try to stop this and where you're going to go with this. Because to me, if they never had a right to bring you to that courtroom, I don't care. Gloves off.
Yeah.
I'm going to be cordial, but I'm going to be very stern.
I just wanted to end.
Absolutely. So,
If you
Can you
want
tell me,
to,
I'm sorry to interrupt you. Can you tell me, do you have a court reporter that you like to use, they suggest in Southern California that you kind of used before?
not me, I never use one.
No court reporters? Okay.
No, I don't, but the people that I talk to all the time, all these people use court reporters. I tell them, don't ever, if you go to court, you should never go to court without a court reporter. Ever. You can call the court, you can find out they're there, there's some of the groups in people they use court reporters.
Yeah, I have a few. I was just hoping that maybe we had somebody on our team, but okay.
Absolutely. You check with them and then they'll be able to use it, because you should never go to court without a court reporter, because you might as well just kiss your butt goodbye. But they're gonna do whatever they want to do to you when you go inside there.
Yeah.
So, is there any other questions, things like that for Lorin? Because I know it's getting kind of late for him right there. So, any other questions, comments? Raise your hand right now.
Just want to thank you for sharing your story with us, Lorin.
no problem. Thank you for having me. It's a pleasure being here.
Hey,
Yeah.
Lorin, thanks again. How's TJ doing?
Doing good. Doing good. He had he got some things to overcome, but he's doing well.
Good.
Guys, in this, I want to call it a game, but I don't know if you guys remember that Fred and Nina.
Oh yeah.
The guy from Arizona, not Richard. If you're putting out good information and you're really trying to help people, they really try to shut that down by any means necessary. And I bring up Fred, Nina, and some of the other people that I know that they've put in jail over nothing, because they don't want you to educate anybody else. And I think we have a duty to each other to help each other and educate as many people as we can. And that's why I do what I do.
Yeah, thank you very much. Lorin, do you have any way to follow you? Do you have any social media or anything like that, or
I don't
websites?
do very much social media. I can give you my email address, and I don't really care. I can give you my email and my phone number. I don't care, man. I'm not afraid of these people. This is a streaming, right? You have to get it from Richard. Call Richard.
Okay.
Yeah,
Okay.
go through Richard, and that's probably the way to go. That's
Yeah,
probably
go
the
through
right.
Richard.
Yeah.
Yeah, go through Richard. All right, guys.
All right, Lorin. Thank you very much. It's a pleasure.
Thank
having
you,
come.
Lorin.
Thank you.
That was
Welcome. Thank you,
great.
guys.
Appreciate it. Hang in there, dude.
Thank you.
Thanks
All
for
right,
taking the time.
no problem. Have a good one.
You
Bye-bye.
too. Thank you.
Yeah.
Okay, one more thing, guys.
Thank you, Hank.
I'm trying to get somebody up in the valley to start some recalls on some of these judges here in LA County.
I'll sign.
So as soon as I can coordinate with that guy, we might be able to start some recalls soon.
Yeah.
And Richard, I probably need the names of those judges too.
Okay.
Yeah.
Got a few names for you.
Well, see,
Yeah.
Hank's done that before. Hank's worked in recalling judges and stuff like that.
Well, I worked in recalling city councilmen.
Hmm.
But then
How about
again, well, I haven't done either the Davis or the Newsom recall. So, but nevertheless, I did help get some councilmen recalled in Bell Gardens, both in 91 and 99.
Wow.
So,
Hey, have you heard of Richard? Have you heard of Richard Fine?
Oh,
He was that was the guy who was
He's been on here. He's been on our call here.
Oh wow.
Richard Fine, is that the guy that has that that claimed that
Yep.
some of the judges were on the take or something?
Yeah, he was in the jail for 14 months because he called him out.
Oh, that one, yeah.
Yeah. But that goes to show you, I mean, they find all this stuff out, the only way it's going to end or stop is when we all come together. And I'm not just talking us, I'm talking millions and millions and millions. It's going to take that amount.
It's possible, all right?
Yeah, anything's possible. Anything's possible. So.
Do you think it will happen with voting?